Yeah, please. My lord, item number 27. This matter is listed for hearing today, my lord. In this matter, my lord, previously also some time, my lord, time was taken, my lord. Actually, my lord, in this matter, senior counsel, Mr. UK Nair, has been engaged. My lord, he is out of station, my lord. Kindly, this may be taken up in the next week.
We'll hear you.
My lord.
2015 matter will
Yes.
not adjourn. Reject it.
Hearing number 26, my lord.
Prayer for adjournment, reject it. Yes.
Oh, please.
Yeah, my lord, I
We'll see what the matter is about and then take a call. Yes.
I beg to mention item number 6, my lord. With the consent of the other side, my lord.
It is IF filed by me, my lord, regarding SMDC precedent. There is a stay order.
Item number?
Difficulty.
Seniority, senior advocate, my lord, out of station, my lord.
Sorry.
My senior advocate is out of station.
Who is your senior advocate? Who is your senior advocate? R. Islam is out.
Yeah.
If Mr. Sharma agrees, we'll adjourn it. If he does not agree, we'll reject it.
I agree, ma'am.
Agree.
Next week,
Adjourn on the prayer of MS, your name?
A. Hussain.
For the writ petitioner.
petition.
For the writ petitioner.
I am for the applicant, private.
May please, your lordship. I beg to mention item number 24 of today's list.
24.
In this matter, your lordship directed us to take instruction whether the
We'll let the item be called. We'll look into it.
May I please, Lordship? Lordship, I would like to mention item number 26 of today's list with the consent from the other side.
Reject it. Reject it. Yes.
May I please, your lordship? With the consent of the other side, I beg to mention item number 22 and 30 of supplementary list, my lord.
22 adjourn. Your name?
S. Hazarika.
S. Hazarika for?
My lord, respond number 5.
Responder 5 adjourn. Yes. And other one is?
30, my lord.
30. What is 30?
The learned senior counsel Disciplinary is engaged, my lord. He is out of station.
Okay. Same adjourn.
My lord, next week.
That we don't know.
My lord. Obliged,
because there is a huge rush for
my
matters
lord.
being listed.
My
So
lord,
adjourn matters, you.
Well, understand.
In item number 22, there is the interim order, my lord.
Obliged.
There is an interim order in 22.
Item 1 for motion.
HMR Chaudhary. What compassionate?
No, my lord. In this case, my lord, manipulation in the selection process, my lord.
Selection for?
My lord, kindly see page.
Constitute an independent inquiry commission.
My lord, page 42, my
to
lord.
let it verify the original mark sheet of all the selected candidates. Why it should be done?
My lord, kindly page 42, my lord.
42.
42, my lord. Serial number 6, my lord.
Serial number 6, Misbah Ahmed Loskar.
My lord, his marks in HSLC was shown as 79%, my lord. Now, my lord, kindly page 4.
Acha, it is something different. The respondents in the elementary education department to produce the entire records of the selection of assistant teacher of LP School of Hailakandi district pursuant to advertisement dated 11/2/2023. More particularly, the mark sheet of the candidates as were relied upon. List on strength.
Item 2.
In 4 minutes for delivery of order. For the last.
Oh, that
Yes.
we'll pick up after some time.
Yes.
At the end of the list.
2 and 4
that matter, the EWS one.
Yes, that chart was finally given by the joint BM.
And you were trying to again interpret that second proviso.
Yes, I
Means your basic case is second proviso has to be read in the way petitioner is interpreting.
No, not
I think that's the only case you are making
well,
out.
it's an exception to the main clause as it should be in terms of the Supreme Court judgments that I have relied upon.
Produced, where are the Supreme Court judgments?
On the last
You
opinion,
give the list of those.
I have given on the last occasion, Lordship.
No, occasions is, we can't retain all these things.
I have given one compilation also. In fact,
Compilation was check up if there is in the record, otherwise you produce. If it is there, it's okay.
Yes.
But otherwise, we don't have the facility to retain all this.
But that is the one I had given.
So normally, I always return it back.
No, Lordship said noted down even the paragraph numbers on the last occasion.
Sorry.
On the last occasion, Lordships had taken the paragraph numbers also. On the last occasion.
What last occasion?
On the last occasion,
we don't know any last occasion, first occasion. We want the judgments you are relying on. That's
yes,
all. And see that it is available. Ensure it.
I've given.
Yes.
2 and 4. Item 3.
Yes, Mr. Bhuya.
My lord was instruction was sought for, my lord, regarding that.
Webinar new yes, what happened to this?
Yes. Well, regarding the last order, my lord, Lordship has directed the my lord,
no.
The officer to my lord respond as to why, despite the honorable court's order.
Who? Which officer?
The
new officer.
No, my lord,
officer, my lord.
No. Last order is B. Gogoi states that a webinar with NUPA is scheduled.
Yes. In fact, it was held. And now finally,
page 63 is the order.
May I place it, my lord?
Special view of the special officer. Why did he say so?
My lord, according to my instruction,
if there is a court order,
she was not aware of that. She has admitted.
Who is preventing these officers from being aware of court's order? Why the court's order are not placed before them?
It was a duty of the petitioner to at least serve a copy. He has got
No,
order.
petitioner does not have a duty to go and serve each and every officer of the department.
No, not to the officer, at least to our.
He did not serve a copy.
I have served a copy to the director of elementary education.
That is good enough. Director should ensure that it goes to everybody, all the relevant officers. Because one litigant, after opening the order, cannot be expected to go to 10, 15 different offices. That here is a copy for you and here is a copy for the other one.
Well, he rendered the apology, my lord, because he was unaware of the
one respondent given, it is his duty to circulate it. If he feels that it is not he, somebody else to do it.
Difficulty still remains, my lord, that correction, my lord, without NIFA's, my lord, endeavor to, my lord, make some changes in that particular portal.
But how can the legal right of the petitioner be taken away by NIFA?
This has been deliberated, my lord. They are having a my lord webinar, my lord, already.
No, webinars are facilitating process. They are not the end of the means.
My lord.
Suppose there is a genuine wrong.
My lord.
Why will it not be corrected just because my computer is locked? No more. Then you throw away the computers, go back to the manual method then.
What I pray, my lord, if
Mr.
I understand, my lord.
If computer is the problem,
cannot be deprived, my lord. Yeah.
Then the answer will be throw away the computer, go back to your .khata system where you can do it. Computer is only to help the process, not to obstruct the process. And this NUPA cannot be so high-handed. Who are they?
Why, my lord, if my lord, it is implemented in the present case, then they will know. Otherwise, my lord, they are very.
Who is in charge of NUPA?
It's a register.
Where is he located? Delhi?
New Delhi.
Please give his address. We'll ask his personal appearance because there is no other way out.
It is headed by the Vice Chancellor.
Vice Chancellor, we don't want. Who is a relevant officer?
Lordship, if allows me, item number 9 is also similar. Lordship, here the webinar was held. Thereafter, the NUPA wanted that a formal proposal should be given. It was given to them. And yesterday, the SSA authorities received an email in the evening wherein they have.
What does it say? They are doing something or they are not doing something?
No, that with regard to the rectification or correction of any genuine grievance, they are silent. They have given only that till 2017-18 as per direction of the
ministry. Who had given that communication?
This is a communication.
Register. The registered NUPA to remain personally present before the court on so and so to explain as to why an obstruction is being caused by the state authority, who is the custodian of the DISC code records, in not correcting even the genuine mistakes that may have crept in.
Lordship, there is one issue because as per the direction of the Ministry of Education, they have stopped collecting the data with regard to management from
Mr.
2018.
Chaudhary, suppose you are a bank, today you stop collecting deposit in my account. Do you mean to say my previously deposited money, I cannot handle it?
Yes. Now then, only the Ministry of Education can.
No, direct. No, it has to be done. Yes. Or else, where is Mr. RKD Chaudhary? I think we'll need him. Ask him to sort it out.
Yes.
Because there cannot be a law that if it is a mistake, accepted mistake, it can never be corrected. You face the consequence of my mistake. I will not correct it because I believe in NUPA, I believe in ministry, I believe in computer. Everything is locked. Nothing beyond that. It cannot be, Mr. Chaudhary.
Yes.
Even those GST authorities were taking that same view some time back. But ultimately it is correct.
Yes, yes.
They found a way out how to correct it. And that's the basic fundamental of a law.
Lord,
you can put in a more stringent procedure for verification. We accept that. Maybe. Suppose these may be fraudulent claims. But that doesn't mean the door is absolutely shut. Is he available or in some court? Just check up, Mr. Rakeri.
Lord, after filing of the case, my lord.
Yes.
What has happened? The entire district administration is behind me, my lord, and police raid has also been done in my house yesterday night.
And that we don't know.
My lord.
We are concerned with the correction of the data. That's all. We are what criminal actions you have committed. We are not concerned with that.
Only for this case, my lord, the deputy commissioner is asking my presence in his office, my lord. Don't know, my lord, for what reason. My lord.
Mr. Gogoi, you are here as a CGC.
Yes, yes. He is
See, there is an organization called NUPA. It is said that they are the custodian of the records of the DISC code. Computer. They are again governed by the Ministry of Education. They say we are unable to correct even the genuine mistakes. Meaning thereby, a person whose entry was incorrectly made, we don't recognize his legal right because we believe in our system. Our system cannot be corrected.
That cannot be.
This is the communications that are coming. Will you please take note of Mr. Chaudhary? The paper he is holding in his hand.
Probably, Lordship, the authority have sent the wrong data, Lordship.
I don't know what.
That's why, Lordship.
Maybe if the authority has sent the wrong data and now the correct data is available, can it be a situation that it can never be corrected?
That cannot be, Lordship.
Take care of this problem. Take up with the ministry, take up with the NUPA. Give them a window how it is to be corrected.
Lordship, give some time, I will obtain instruction, Lordship, whether it can be corrected or not.
If you say it cannot be corrected, then we are going to say
Lordship,
disband this NUPA or dissociate this NUPA from this DISC code data. Do away with your computers. Come back to the manual system. Maintain it. A system that is brought in for further advancement.
If wrong data is entered, then if the actual data is coming, it should be corrected.
It should be corrected.
It should be corrected.
At the best, you can say that we'll put in a very, very stringent procedure of verification. That is
Then
acceptable.
they can
You can do it.
explore lordship the manual system also. Lord.
Whatever you do,
Lordship.
find a way out. These computers are sometimes creating a nuisance also. I think 2-3 years back, in our court system, কি কৰিছিলে কিবা এটা যে নোৱাৰে কোৰ্ট সিস্টেমত কিবা এটা যে নোৱাৰা হৈছিলে কৰিব we pass our orders the computer system says that it cannot be uploaded so who has precedence computers has precedence or the judicial order of the court is the origin but it is sorted out ultimately
in respect of lordship
no, ultimately those problems are sorted out so if you want to do it you can still do it
lordship may give sometime I will
in like
and lordship I pay for copy also lordship.
Copy of the
my lord
give a copy of the
as well as-
requisition also and also those communications Mr. Chaudhary
soft copy দিব দেই।
one of the issues involved in this writ petition is regarding the entries of the particulars of the writ petitioner in the DIST code. According to the respondents, such corrections now cannot be incorporated inasmuch as the DISC code data are maintained by the institution NEUPA. And according to the authorities of the NEUPA, as communicated by Mr. B. Chaudhary, Learned Counsel for the SSA, the system which contains the records of the DISC code had been locked after a particular period of time, meaning thereby that whether or not the information put in is correct, no further modification of the data can be made. And in other words, the litigants would have to bear with the incorrect data being entered for a deprivation of their legal right. It is stated that NEUPA is again controlled by the Ministry of Education, Government of India, and they're acting under the instruction of the ministry. Accordingly, we require Mr. K. Gogoi, Learned CGC, to take up the matter with the Ministry of Education as well as NEPA and find out as to in what manner incorrect data that had been entered can be subsequently corrected after a thorough verification of the factual aspect. Listen,
my lord, may I pay
a
for
copy of the order to Mr. K. Gogoi.
lordship, after 3 weeks lordship it will
3
take
weeks.
some time lordship, after 3 weeks. Lord, may I pray, my lord, for filing of this petition, the petitioner may not be harassed.
That part, my lord.
Just a minute. Who is harassing you?
Lord, the deputy commissioner, the additional deputy commissioner.
Of which district?
Of Lord Borpeta.
Borpeta.
Last night, Monday.
Just a minute. Give us, file an affidavit. We'll take it up in course of the day. The instances of harassment.
My lord.
The instances of the harassment, please bring it in through an affidavit.
My lord.
It is stated by Mr. A.R. Bhuya, Learned Counsel for the petitioner, that as because of the filing of this writ petition, he is being harassed by the Deputy Commissioner, Borpeta, as well as
Deputy commissioner as well as the SDC also.
by the Deputy Commissioner, Additional Governor, SDC of Borpeta.
My lord.
The petitioner to file an affidavit bringing on record the instances of such harassment. List tomorrow. For this purpose, you list it tomorrow. For your purpose, 3 weeks. The Learned CGC may respond after 3 weeks. This to Kali din. 3 weeks or D2, we'll give it tomorrow so that otherwise there cannot be two dates in one order. For your purpose, we are listing it tomorrow.
Item 5.
So item number 9 is also similar with regard to the item number.
When 9 is called, you will say list along with this one. Yes, Madam.
Lordship, while last order, Lordship was directed to produce the record of the constitution of the governing body.
By slip.
Yes, constitution or governing body records. Adedi, we heard only Mr. Saikia, not Mr. Pegu. Now, who is to produce the records?
College authority have produced the record. College authority. And
College authority.
And university regarding constitution.
No. Who is constituting the governing body? Madam Deka,
Lordship,
by which order these governing bodies are constituted?
Lordship, that order is not served upon me, or Lordship.
By our earlier order dated 7/9/2023, we required all the respondents to produce the complete records regarding the constitution of the governing body of Harbopali Radhakrishnan Teachers Training and Research Institute, Samota. All the respondents mean the state of Assam in the elementary education department through the commission secretary.
Lordship, that is wrongly made a party. I'm sorry for that, your Lordship.
Correct it.
I may be correct. I may
The
be
petitioner
allowed
may
to
correct the cause title. Okay.
Item 7 for admission.
All the respondents the bhul ka karo ite. Madam Deka, your case difficulty is we ordered all the respondents. Now, if the respondents are wrongly depicted, whom do we ask to produce the record? So please correct it. Then we have to hear you once again, because the new respondent we may not have heard earlier. So correct it, please.
This case is relating to appointment of the petitioner on compassionate ground.
Forensic report of the forensic department.
He will appear in this matter.
No, ask him to come after some time.
Item 8.
Regarding non-payment of some arrear salaries and for payment of regular pay scale, my. In this case, what happened, my lord? Originally, the petitioner was initially appointed as OBB teacher, and thereafter his service was regularized and he has passed his DLED, my lord. After DLED for 16/11/2019, he has passed his DLED, my lord.
What happened?
He is entitled to get his regular pay scale from 16/11/2019.
Regular pay scale from 16/11/2019.
19, my.
19.
My.
Are you at present easy paid the regular scale?
I am getting from my lord February 2021.
From now you want it from 19, they are paying from 21.
Yes. My lord, order itself is there, my lord. In their edition, their affidavit in opposition filed by the department, my lord. And apart from this, from there some
which page you are relying on?
Page 5 of the affidavit in opposition filed by the, my lord. Director.
Running page only.
Item 9.
Yes, item 9, who is appearing?
Page number 4.
Item number 9, who appears?
Item 9.
Item number 9, Mr. M.R. Khundakar. Where is it? Yes, please come.
My lord, in this case, my lord, also my name in dice code, my lord, OP is manually corrected in dice name. In dice code, it is not uploaded. So my
same place.
Same.
আগৰ কোনটো matter আছে?
আগৰ এটো কালি ফিক্স কৰাটো পাইছে।
তো কালি এটো কালি ফিক্স কৰিব নোৱাৰো।
না এটো
তেতে It peculiar whole, no? Go karne 3 weeks for the actual response. Harassment or karne kali. It is kali hitu 12 October kori thodi. Itu matter to. Wait till you cover daddy. List on so and so along with WPC. Hit number 2.
I'm on.
Item 10.
Mr. Khan.
In this case, today we are going to file an affidavit in respect of item.
Can we hear the matter today?
Today we are going to file affidavit.
Sorry?
Today we are going to file affidavit.
You are going to file affidavit. Mr. M. Khan and counsel for respondent 6 states that the affidavit in opposition of behalf of state respondent will be filed in course of the day.
Tuesday, my lord.
Next.
It's not that super fast, Madam.
Just now, we have received the copy just now. So.
You have only one individual matter. Registry has to deal with thousands of matters, and there's a huge rush. Let's see when you can be accommodated. Next item.
Item 11.
কিবা এটা দি দিব যেতিয়া সুবিধা হয়
3 তাৰিখ 3 তাৰিখ
So item 11, who is appearing?
Jan.
Number 5, man.
MK Chaudhary, K. Khatoniar, UK Goswami. Where are they? None appears for the petitioner when the matter is called. List again.
Item 12.
List again. If they don't appear, why should I fix date?
But I have urgency because operation stay order is operating against me.
In the list on so and so, in the event of subsequent non-appearance, the interim order reconsideration would be made on the interim order.
Date may fix.
5th October. Item 12.
Where will lost, my lord?
Recon made on the continuation of the interim order. Yes,
my lord, this matter lost when heard earlier, my lord, that Hojai College expulsion of 2 students
Dancing.
Dancing.
Yes, somebody appeared for the college.
Yes, last time
Who
it was-
appeared? He was very
Yes, Lordship. Last time.
strict. That our college is very, very strict.
Yes, Lordship.
Where is that strict college?
We are trying to
See,
buy
one
time.
student somewhere,
That's true, Lordship.
maybe they got a little carried away. Possible. Correct them. Does it mean he will lose his entire education career for that act?
Excellent.
Is the education system in the country operating in this manner? That one small act of here and there, you student, you forget about your education career. Is the education system there to produce criminals or to produce educated people? Once you throw him out of education, he'll go in some other line tomorrow. And what strict college? The principal of the respondent, Hazi Anfar, to remain personally present before the court on the next return date, inasmuch as the learned counsel for the said respondent has not entered appearance today when the matter is taken up for its hearing. List on next week video. The order will be communicated to the principal through Mr. S. Bhuyan and counsel for the higher education department.
Item 13.
Who had passed the order? Principal.
Hello. Next.
Mr. Bhuyan. At one time, you may have to take some disciplinary action against these colleges.
Lord,
Rather than maintaining an friendly educational atmosphere for the students, if they are going into some other aspects,
yes, sir.
it's better they don't operate an education institute. Ask the director to take
Yes, yes,
to give a show cause to this
Yes,
school.
I will do.
That why is it done in such disproportionate manner?
Yes, I will do.
And on the next day, give us the show cause also. Tell the director to issue show cause notice to this college why they had done so.
Some reflection.
Sorry, no. On your own. In fact, you should have done it on your own, being the director. You can't be a silent spectator of all this.
I'll oblige. Can a copy of the order?
What copy?
Order.
We have not passed any order.
No, not that order. The earlier order. This calling the principal lordship, that order.
No, that also you
I'll
don't
take
need.
up. Oblige. I'll take up. Okay.
Item 13. Yes, madam, 13.
So, Lordship, the respondent number 5 not to be filed their affidavit.
Respondent number 5, not filed affidavit. A Chakrabot, J. Tamuli. Where is Madam J. Tamuli? You are there?
Yes, yes.
For which respondent?
I'm for the private respondent, my lord.
Number?
Number 5.
5. Last time some J. Tamuli appeared.
Yes, your lordship.
You have not filed your affidavit. Why?
Almost ready, my lord. Even today itself, my lord.
Mr. Aham Islam, appearing for respondent 5, states that the affidavit in opposition is almost ready and it will be filed within?
My lord, tomorrow, my lord.
Within 3 days. Pray aloud.
Departmental instruction also necessary in this.
What instruction you want?
Because regarding principal in charge, Lordship, that's
No, there is no such order. Did you issue notice in this matter?
Lordship.
Yes, your lordship.
Notice is issued. No? The respondents in the which higher education or secondary education?
Secondary education.
Second, to also file their affidavit by the next returnable date. List announcements.
I put the respondent number 6. We have filed our affidavit.
You have filed? Very good.
Early oblige, your lordship.
14.
Your lordship, the petitioner has put to challenge the order at page 52
Are you hearing the matter today?
We are ready, Your Lord.
Mr. Mukhtar,
Ready
ready?
for standard 4, my lord.
Mr. Sharma? Ready? Sure. If you're ready, we'll hear you. No difficulty. Yes, sir.
Lords. Here, Your Lordship, we have put to challenge the order dated 27/1/2023, Your Lordship.
Page number?
At page 52, Your Lordship. By this order, Your Lordship, if Your Lordship comes to the fourth paragraph,
গৰম কৰিব নোৱাৰি নেকি? সেইটো নহয়, সেইটো ঠিকে আছে, এইটো। সেইটো এনেও দিছে, সেইটো উল্টা গৰম হৈ গৈছে। বৰষুণ দিছেতো, মানে ফুল মানুহৰো বেমাৰ হ'ব তেনেকে। Are you not feeling a little more cold?
Yes,
or it is okay? কাৰণ বৰষুণ দিছেতো, এইটো সেই ৰ'দ দিয়াৰটো দি আছে। মানুহটোক মাতি কিবা এটা আছে ইয়াতে, বাহিৰত কিবা এটা হেৰি কৰি দিওঁ।
Your Lordship may kindly come to
The
fourth
existing
paragraph.
principal, namely Muzammil Haq Mandal, over with
Retiring from service and so on. So accordingly, the
Inspector of School BDC Dhupi by letter dated
four teachers of school for allowing the next senior. On verification of the scrutiny, seniority list of the teachers in other relevant certain anomalies are detected with the proposal for recording of hearing for candidates, including the present principal of the school, conducted at the office number of the undersigned influence. At the time of hearing, it has appeared from the records that senior most Muhammad Nurul Amin Ahmed MABH subject teacher of the school legal circular is presently under deputation to BL supervisor. Moreover, the duplicate BL marks is issued by a so-and-so produced during the course of Muhammad Nurul Amin, which to be very, very important. Now, fourth paragraph relates to us, Your Lordship.
Just a minute. Mr. Sharma. Your view is, as per the Assam Civil Services Conduct Rules 1965,
yes,
a person has to obtain prior permission before going for some other course.
Yes.
Suppose somebody does not do it, what will happen? Will the degree become invalid, or it will be a case of misconduct against that man for a disciplinary proceeding?
It is not acceptable to department as
No,
he has not
no.
taken prior permission.
See, if who gives a degree? University.
Yes.
For the point of view of the university, if the degree was obtained in a legitimate manner, meaning thereby, as the way the university wants, the person underwent the course, way the university wants, the person appeared in the examination, and the way the university wants, person appeared and succeeded in the examination. So that ultimately leads to a degree. If these three conditions are satisfied, how another authority, being the director of secondary education, say I do not recognize the degree? Because degrees are governed by the UGC Act. It's not by the discretion of the director.
Yes.
And director's view is it was obtained without prior approval. That is a serious matter.
Yes.
But will that by itself make the degree invalid?
No.
Or it will be a case of a misconduct against that man? You can initiate a proceeding. If you want, you can dismiss him also. That is your discretion. But here you say, in view of no one can be allowed to hold charge. Why? because somebody obtained degree without prior permission from the appointing authority, meaning thereby you have de-recognized the degree itself. Can it be done?
Degree cannot be. Degree is valid. It is misconduct.
Director could have said that you obtained without permission, this is a misconduct. I place you under suspension. Very well. As you are suspended, you cannot be de-incharged. We will accept it. So, all of you are aggrieved by this order, or some of you are supporting this
My
order?
case is concerned, my lord. Only I could not place the, my lord, original mark sheet on that day.
No,
my
no.
lord.
Whom do you represent?
I am responsible for 4, my lord, the senior most teacher, my lord.
Namely, that
Nurul Amin Ahmed.
Nurul
Nurul
Amin Ahmed.
Yes, my lord. In
Are
my
four.
case, I could not produce the mark
But
sheet.
by this order, you are also rejected.
No, my rejection is only on the ground that it is to verify.
Mr. Mukhtar, your ground may be a lesser evil than the other ground, but you are also rejected.
My lord, my lord.
So if you want to overcome this, you'll have to file your writ petition challenging this order. In his writ petition, we cannot take a call that Mr. Mukhtar's client is having a lesser evil. Mr. Borthakur's client is having a higher evil. Give it to Mr. Mukhtar's client. We cannot pass that order.
That is true. Only in my case, only verification was to be done, my lord. That has been done already, my lord. Inspector has made the verification. It has been found genuine, my lord.
Where? No. In view of the above, no one from the above can be allowed.
That part is true. That part is true. My lord. But your lordship will find
Subsequently, verification is done. Subsequently, verification is done, your
Yes,
lordship.
madam.
But you are challenging this order.
They are
He is
challenging for
not.
their benefit,
And
my
your
lord.
lordship will kindly note, your lordship, his B.Ed degree also, he has also not got permission to take permission from the authorities, your lordship. But he was
That is
handed
true, my
over, your lordship, academic charge, your lordship.
Being
Thereby,
senior
your
most, my
lordship, they have, your lordship, applied different yardsticks for the both the group of teachers, your lordship. That they could not have, your lordship. And there his insertship has, we have put to challenge, your lordship.
What order we passed, Mr. Sharma?
My lord, at the time.
Go back, take a fresh decision.
Yes.
Who should be the in-charge principal? By taking note that degree which is obtained from a university and otherwise valid cannot be de-recognized on the ground of this one. Because at the best, it can be a misconduct. If it is a misconduct, proceed under the discipline and appeal rules. And not that I'll not take note of the degree. And whoever survives, give that person.
Lord.
Assam Civil Service Conduct Rules.
Rule 13, your lord. Page 415, your lord.
This same color book?
Lord.
415.
Rule 30.
415. Which provision, Mr. Sharma?
Rule 13. Your lord.
13.
কোন institute of
or hold any electist office. Is there a word called electist? আছে dictionary কোন আছে? Dictionary কোন any Oxford বা যেকোনো এখন
elect students
Oxford electist also নেই
It should have been probably elected, your lord.
No, I've not heard this word. So see if it is actually there. নাই পোৱা শুনা নাই
তোমালোকে ফটোকপি ক'ৰ পৰা কৰিছা? এখন ফটোকপি কৰিছা নেকি? In the original, your word is elective.
Elective is there, we know.
In the original notification that downloaded.
Achha, this book is
typographical error in it. Elective. We did it, your lordship, without affecting the classes through correspondence. Normal duties has not been affected.
UGC accounts, no?
UGC
that person does not belong to the creamy layer. Suppose there is a parents who has a good fat job of 10 lakhs per month salary. And those parents, once you have 10 lakhs, you don't have to do anything else in this world. You work, get your salary, enjoy your life. So naturally, that parents will not have income from any other source because you don't need. Do you mean to say, by virtue of the interpretation you are trying to give, that family will not be a creamy layer? What is cream?
Depend on the post.
So therefore, not depend on the post, depend on the money. Creamy layer is absolutely economic. It is nothing to do with status or anything like that. I think this interpretation needs a reconsideration. We'll hear you on final hearing. Mr. Gogo, even today is?
Lord, we have to be by next week because 30th September.
Before we have to be. Next. Hali, itu kunibo lagibo. No, itu medical. No, itu bele creamy layer. Mr. Govi, Mr. Bolra, come prepared with all the relevant case laws on this creamy layer issue. We'll hear and decide it. That day I passed an interim order, thinking I'll hear it in the meantime. But this interpretation may not be absolutely correct. Your submission.
Already a coordinate.
Because the whole purpose will be defeated. Just see. Or agriculture income also exceeded. A big time farmer who may be earning in millions, he will not be creamy layer by virtue of this interpretation. Is it rational?
Coordinate bench, my lord. One judgment is there.
Some we don't have. Suppose in places like Punjab, etc.
Yeah.
A farmer may be as good as an industrialist, and his income will be from agriculture farming. So he'll be excluded from being creamy layer. Difficult to perceive that situation.
Coordinate bench, my lord. One.
Sorry.
Coordinate bench, my lord. One judgment is there, my lord. I have annexed that judgment, my lord.
No, we'll interpret the provision. We'll also take look at what if had the coordinate bench interpreted the provision. No.
Otherwise, facts are identical, my lord.
Facts may be identical, but was the law interpreted?
It was, my lord. It was.
Let's just see how it was interpreted.
Your lordship, my lord, kindly takes, my lord. It starts at page number 79, my lord.
79.
79. My lord, I'm sorry.
No, even if it is interpreted and we are not satisfied, we'll take a look at it.
Page number 81, it starts.
81.
81, my lord.
81.
It starts at 81.
Where is it interpreted that if it is income from salary and income from agriculture, that will not be taken for the purpose of creamy layer?
Relevant paragraph, my lord.
Page number?
Page number, paragraph 13 starts at 85, my lord.
85.
85 it starts, my lord. And 86, my lord. Fifth line, my lord.
Fifth line.
Fifth line. Fifth line, my lord. Page number 86 from top, fifth line.
It has further been mentioned, that one.
My lord, correct, my lord. It has been further mentioned that in respect of category 6, which pertains to income wealth criteria, the gross annual income of 8 lakhs or above or possessing wealth above the exemption limit is prescribed in the Wealth Tax Act for a period of 3 consecutive years would not be entitled to creamy layer. But in that case, the income from salaries or agricultural land shall not be clubbed. In such cases, the income has to be taken from other sources of wealth, which would bring
Mr. That is regarding wealth tax. Wealth tax, this provision may be there because if this income is not included in the wealth category of wealth tax, it will be taxed by virtue of income tax. So therefore, this interpretation is there. Otherwise, it will be a case of double taxation. But here is not a case of interpreting any wealth tax and income tax. Here is a case whether somebody comes within the non-creamy layer. What is non-creamy layer? The economic status of the parents. What is economic status? How much money they earn. Immaterial of any source. Ultimately, the purse that you are holding is the deciding factor. So this interpretation possibly is inapplicable in this case.
My lord, page number 89, Honorable Supreme Court has also, my lord, interpreted paragraph 3, my lord.
Paragraph 3, page
89, my lord. Honorable Apex Court has, my lord, interpreted.
Regarding non-creamy layer?
Non-creamy layer, my lord.
What has it interpreted?
My lord, paragraph 3, my lord, it says, my lord.
It is admitted that the appellant that the only source of income of the father is his salary. It is not disputed that the father of the appellant in class mother is not a class student.
The amount of gross
salary received by the father of the appellant for the purpose of grant of benefit is irrelevant.
This is, my lord.
There must be hundreds of other judgments by the Supreme Court. This is not relevant for this purpose.
Your lordship will decide.
We are determining creamy layer.
No.
And you rely on some 2004 say that income from salary and income from agriculture has to be excluded to determine whether you are creamy or not.
Correct. That is
We are finding it a little incoherent, in fact, that proposition.
In fact, my lord, I was there on the other day, that coordinate bench judgment, my friend was there for Union of India.
No, give us the rational logic behind this. How we should accept that income from salary and income from agriculture is not to be taken account to determine whether a person is creamy or non-creamy. Why?
Because, my lord,
there has to be some logic.
The logic perhaps is in
a man with a 10 lakh salary per month, he'll be non-creamy. Why? Because he doesn't have income from any other source. Give me one person who earns 10 lakh a month, will also have another source of income. He'll not have also. He'll be happy with his 10 lakhs. So definitely his other source will be zero. So by adopting this formula, do you mean to say that that family will be a non-creamy? Because earning 10 lakhs, he doesn't need any other source. So he's a non-creamy person. Ultimately, the purpose of this reservation will be defeated, Mr. Borua.
Your lordship will decide in light of the appeals based on record. Let the government file.
There's a possibility we may have to go against you. To substantiate, you bring whatever judgment you have.
It may go either way.
For your support, you bring us whatever proposition of law you have.
I'll get whatever I have.
We'll hear you.
On top of that, my lord, the petitioner is, my lord, relying upon that XCGL category. So that will be, my lord, from tomorrow inspection will start.
Your certificate will go also for
that. That hurdle he will have to, my lord.
Has it started?
My lord, yesterday meeting was held, and from tomorrow, my lord, in the DME's office, in the conference hall, the committee will sit.
No,
and
that committee will sit in the DME office
yes,
itself. It's better.
Yes, and all the students have been already mailed to be present from tomorrow, including the present petitioner might be.
Ultimately, they only gave us the OBC non-creamy layer certificate. Somebody made some complaint behind my back. And they,
No. We are not only complain. Whether factually you belong to non-creamy or not, we will determine it. If it is yes, definitely we will pass through. But the principle of law you are propagating, that prima facie not very appealing.
Try to satisfy.
As straightforward list on. Medical admission. So that there is sufficient time for them to act upon it. Very many video. Azik Mandari. Dekoi. We'll hear on 25th. Because suppose we go against you. One, you must have time to go in appeal. Two, they must have time to appoint somebody else in your place, whosoever is a deserving candidate. So we'll hear you on 25th.
Right.
Sorry to interrupt, Lordship. Item number 12, Lordship.
Please don't interrupt. If you want, tell the court master, it will be called
16
again,
for orders.
if necessary.
Item 16 for orders.
Yes.
It is a contempt petition, my lord. The contempt number 2 earlier appeared
Last order. So
ND Sharma PT praised for 3 weeks time to file appropriate application for implementing necessary party. That is the last order.
Madam, that is perhaps in for other order has been other for other case has been earlier order, madam.
This is item number 16.
16, madam.
Contempt case 71.
Yes.
Last order is Mr. Sharma praised for 3 weeks time to file appropriate application for implement of necessary
I
party.
am not S Sharma, madam.
ND Sharma.
SK Roy, madam.
No, ND Sharma will লিখা আছিল তাত।
Please, এখন দেখা দিব।
In other case, this
We don't know, Mr. Counsel. See, we are only reading the order that was before us.
NM Sharma বুলি এজন আছে ন, সেইটোকে ND কয়। ইয়াত NM Sharma বুলি আছে ন তোমাৰ লগত। PM Sharma। Anyway,
my lord, actually, the contempt present incumbent has been already implemented.
Mr. We don't know. That is a judicial order on record. We are only showing it to you.
My lord, on 21/6
We understand everything what you were saying, but what to do with that order?
my lord,
কিন্তু বেলেগৰ order বেলেগত মাৰি দিছে নেকি তেতিয়াহ'লে চাওকচোন।
Otherwise, the present incumbent is in party lawsuit. Then notice.
নহয় বেলেগ মেট্ৰৰ order বোধে
yes,
বেলেগত
madam.
মাৰি দিয়া
Perhaps
আছে।
it's-
Perhaps it's something like that.
list after earlier order.
Or else we listed before that court which passed this order. Only that
Yes.
court can recall this or something.
Yes.
Something is, it appears something is wrong.
My lord,
Or else you do one thing. File an application to recall this order, we'll recall it. Judicial orders can't be thrown away.
Definitely fix when I am tomorrow or
File an IF to recall this order, then we'll proceed with the matter. Otherwise, this is a stumbling block for you.
and on that occasion, actually, my lord, it was actually, my lord, the 3 weeks time was asked by this by my lord.
We understand everything. But once a judicial order is on record, we cannot say anything. Safest course for you, file an application to recall that order saying it was wrongly recorded. We'll recall that order. Once we recall that order, that obstruction on the way will be removed. Then we'll proceed with your matter the way you want. It is stated that the order dated 21/6/2023 in contempt case 71/2022 had been wrongly recorded. Petitioner may file appropriate application for recall of such order.
Item 17.
17 lawsuit, I need some information. We have already sought a report from the DO lawsuit. Earlier, you have submitted on report, but that on verification, some documents were not found in proper lawsuit. So we have sought another report from the DO.
Notice is yet to be issued.
But I was notices, I think yet to be issued. I was directed to appear.
No, just see.
That is where.
Oh, bro.
bro.
Mr. Chisti, you must have made a submission, we recorded and passed that order.
Yes.
Either you have made a submission in a wrong matter or
Notice is yet to be issued.
In this case, my lord, earlier, my lord,
Notice should go lawsuit. I will take it.
I think let us issue notice
my
first.
lord, in this case, what happened, my lord? Earlier, my lord,
Mr.
Dr. Vijay,
Islam, which order is violated? Page
my lord,
number?
page, my lord, 5, my lord.
Page 5.
Answer one, it's the from page four.
Not page 5. Page 5 is the part of the writ petition,
My lord.
contempt petition. Page 9.
Payment of area salary, my lord. Petitioner was suspended, my lord. That later on his period was regularized, my lord.
And what order was passed? Mr. Chisti, do you have the copy of the petition with you?
No, Lordship, that,
Mr. Islam,
this is a, I don't have a copy.
please give him a copy of the petition.
May I read the order, Lordship?
At times what happened, Mr. Chisti, when you call the matter, Mr. Chisti?
Yes, sir.
Sometimes what happens when you call the matter, the learned counsel gets mixed up with the case and makes a prayer that I want 2 weeks to file affidavit.
Yes.
And when a state counsel prays for 2 weeks to file affidavit, we normally don't look into the file.
Yes.
We believe that is a
Yes,
correct
yes.
submission and we grant you the time you want. This possibly that had happened. Submission which ought to have been made in some other matter was made here.
Yes.
Now here the direction is, there is a direction that the after proper verification of the fact shall take appropriate action so that the petitioner gets his arrear pay and allowance for the period he was under suspension. Did you pass any order?
No, Lordship, we have certain report from the DO, Lordship.
In this matter?
Yes, in this matter, Lordship. And the
No, the direction is to the director to pass the order, not to the DO.
Yes, Lordship. Some clarification was sought from the DO, that is in this.
Mr. Chisti, we are trying to help you.
Yes.
We can issue notice of contempt.
Yes, Lord.
But why should we issue? It's only a simple direction
Yes.
that verify the facts and pay him the salary. If you have paid, tell us. If you have not paid, do it.
Yeah, we have not paid yet, Lord.
Then do it.
Yes.
We'll give you 15 days more time to do the needful.
Yes, yes.
Unnecessary, why you
Yes, yes.
burden the registry with all these pendencies?
Yes.
Heard Mr. R. Islam, learned counsel for the petitioner, also heard J. Islam, sorry, learned counsel petitioner, and also heard Mr. S.M.T. Chisti, learned standing counsel for the respondents in the elementary education department. This contempt petition is instituted alleging willful and deliberate violation of the order dated 22/11/2021 in WPC 6161/2021, the relevant portion of which is extracted as below. A reading of the afore extracted portion makes it discernible that there is a direction to the Director of Elementary Education, Assam, to make a proper verification of the facts and circumstances of the claim of the writ petitioner therein, and pass necessary order regarding the payment of his arrear pay and allowances for a period under which he was under suspension. Considering the nature of the order, we have been informed that the director has not passed any order as directed. In the facts and circumstances case, we have the view that the interest of justice would be met on a direction being issued to the Director of Elementary Education, Assam, reiterating the order dated 22/11/2021 with a further direction to pass the necessary order within a period of 15 days from today. Rather than issuing a notice of contempt. Contempt petition disposed of with the above direction, with the expectation that the director will duly comply with it within the time frame as indicated. If he does not, next time,
yes,
personal appearance straight away.
I will intimate, Lord.
Item 18.
Notice was issued, my lord. ID card has not come.
Any reply? Some
The service is yet to be completed, Lord.
service on which respondent?
Respond number.
This is a contempt matter.
Contempt.
I was seen the office note of 89. Did you read the office note of 89? No. Read it first. Next item.
Time being. Item 19.
As per the last office note dated 18/9, Lordship,
18
neither the AD card nor the
June
answer
19.
notice has been
With
received.
service report
On the note 4, Lordship, that was
with reference to the office note dated 18/9/2023. List again.
20.
So this matter is also similar with item number 5 here, Lordship. We earlier also challenged the action of the circle officer in interfering our society's action here, Lordship. And
Sorry, what was item 5? You already did.
item 5 is Lordship,
So
I
now
have-
also you want to correct the respondents.
No, here here is no mistake, Your Lordship. Now, regarding item number 5, Your Lordship, I have one prayer, Your Lordship.
Item number 5 is over. We cannot go back. The
Then,
day
Your
it is
Lordship,
listed, you tell us what is to be done there.
This matter
Now
may-
this matter, what is to be done?
This matter may also be taken away along with item number 5 in another date, Your Lordship, because both the matters
As paid for by MSR Lekha, like government petition, list along with so and so. You appear for somebody.
Respondent number 7. My here they have already filed separate one. Moreover, somebody they have already engaged someone else.
21.
Yes, what is to be done?
On the last occasion, 31st May.
No, on the last occasion, none appeared for the petitioner. If you begin with the line last occasion, no one appeared for the petitioner.
Yes, yes. On the occasion of 31st May.
Sorry,
On the occasion of 31st May,
on the occasion of 31st May, yes.
issue notice and service was complete. And on the latest occasion, 7th August, non-appearance for the petitioner. Stage is right now in this.
Sorry.
Case is right now in this stage.
No, that much we understand. Now, what is to be done today?
Yes, pack of the case.
No, today what is to be done?
What is to be done? Yes, Lordship.
আজি কি কৰো এতিয়া কেছটো শুনিম নে আৰু কিবা আছে
Yes, to be heard.
to be heard today. Are you ready?
No, my lord, it is an order matter, so my lord, 3 weeks may be granted and.
There's nothing called order matter cannot be heard. You want 3 weeks time for what?
For filing affidavit.
Why don't you say that? 3 weeks time granted for filing of the affidavits by the Secondary Education Department on the prayer of Mr. U. Sharma and sending on. Just after 3 weeks.
Item 23 for hearing.
Lord, can I take little liberty in this case, my lord? Yesterday I came from Delhi and it's very late, my lord. Some little accommodation, my lord. And my learned friend is also not very well today. I know it's an old matter, my lord.
If we put up the order sheet in the public domain, the blame will be on the court. Blame will be on the court if we put up this order sheet in the public domain.
Some cases, my lord, are unfortunate. Even if your lordship has made so many, and the your lordship heard so
Somehow
many
it
times.
has not culminated.
But I don't know why. And yesterday,
And then
as-
release from part heard.
No, no,
Let
your
it be
lordship,
listed before the
that
appropriate
lordship
bench.
will not- my lord,
Because otherwise the blame will be on
No,
this court.
no, no.
That the court is
My
not
lord,
doing
today-
anything at all.
Today, your lordship, he has come from there.
No, we
And
understand.
So
We are
what
not saying
happened last night? What happened? I'll say, my lord, without any reservation. 2:30, I had so much pain, and in the morning when I was told, then I rushed to the court.
Then what to do?
I can, no, your lordship.
Maybe after 7 days, my lord.
17 October.
No, 17 October. Actually, my lord, yesterday our matter started. Then all of a
17.
sudden, because there was some a non-conformity regarding the SOP framed by the Supreme Court, if our matter has been fixed for day-to-day hearing from 17. So before that,
Before 17 October.
17 is.
17.
No, 17 don't want
4th October.
Third.
Fourth.
Both of both things.
Fourth.
Sorry,
We have
it will be
third.
fifth, third or fifth.
But by the fifth one matter is coming before.
No, you take your convenience.
But
Can it be 10th of October, my lord? It's a Tuesday.
Yes, 10th is okay.
It is agreed and prayed by both Mr. D.K. Mr. Lansina Conservative Appellant and Mr. Ken Chaudhary Lansina Respondent that the matter should be fixed for a hearing on
10th of
this accordingly.
Deeply.
Item 24.
As per your lordship.
You said something in the morning, I think.
Yes, sir. As per your lordship's instruction, we are supposed to take
Instruction. We don't give any instruction. Your client gives you instruction.
Direction. We are supposed to take instruction whether the post of subject teacher that is still lying vacant in the Pittsburgh High School. We have sent them a letter, but we have not received the instructions.
For whom do you appear, Mr. Dotto?
Respondent 4.
College authority.
Yes.
Two 2015 matter.
15. Each time may be granted.
And there is no interim order in your favor. Earlier it was there, but dismissed for default. After that, no interim order. Post is filled up.
We have sent them a letter. We have not. We are yet to receive the instructions.
Who is the person to give you instruction?
The principal, the secretary of.
It is stated that the necessary information as required by the order dated 31/8/2023 is required to be provided by the principal of Pittsburgh Girls Higher Secondary School, Dibrugarh. Mr. Dotto states that the principal has not provided the necessary information. List on so and so for the information, and in the absence of the information, the principal to remain personally present.
25. So,
None appears for the petitioner when the matter is called. List again. In the event of further non-appearance, the appropriate order shall follow.
26.
Same order.
27.
Next week, money D.
Next week or
I can finish it.
20? Yes, please argue.
Worship,
No adjournment.
This arm assume is not keeping well. He is prepared with the case.
Doesn't matter.
May this matter taken up
Doesn't
tomorrow.
matter. It's too old a matter to be taken up in this manner. You are here, please argue, we'll hear you.
Worship, I'm not prepared with it. Please accommodate me first.
Sorry.
Okay. Tomorrow.
It should not. It's against the constitutional principles to adjourn.
May this matter be taken up tomorrow. As a last
No, tomorrow, why should you list? There must be another 100 of person lining up for listing it tomorrow. It is today here. It's and there is nothing that a junior counsel cannot come prepared and at least tell the basics of the matter before the court. There's no such law anywhere.
The matter pertains to the selection and appointment of a copyist in the
You read, tell us, we'll take up after some time. Take the file, court file, if you don't have.
My lord.
Don't ask for adjournment.
No timing.
No timing. How many cases will do with timing?
Who is it? staying.
Ask him to come.
I'll,
Yes, what is the matter?
This is my lord regarding service benefit, my lord.
Ask him to come. Yes. We'll hear him later on. You take note.
Service
benefit of what?
The petitioners, my lord.
Hmm?
And they were appointed initially under regulation 3F. And my lord, thereafter.
Page 17, subject to discharge without notice, regulation 3F. Post of lecturer. Dilip Chandra Gogoi.
Yes, my lord.
So now what is the grievance?
Grievance is that, my lord, under judicial notification, my lord, there is a provision for granting a benefit. That is one senior scale of pay and other one is a selection grade scale of pay. For those, my lord, for those benefits, my lord, while the seniority is counted, my lord, then whether that ad hoc service period can be counted or not, that is the issue, my lord. And our grievance is that our ad hoc
Sorry, you are appointed 1992 under 3F.
Yes, my lord.
And when were you regularly appointed?
Thereafter, my lord, my regularization is 18, my lord.
Page 18.
18, my lord.
19th August 94. From 19th August 94, you have no difficulty.
No difficulty, my lord.
You, whether the period from June 92
yes,
to August 94
yes,
should be taken for the purpose of your seniority.
Seniority, my lord.
They are not taking it.
They are not taking
If they take it, you will get your senior scale.
Yes, from the initial date of, my lord, appointment under regulation PF, my lord.
Now you are getting it under from 94.
Yes, yes, my lord.
That is your only
grievance, my lord.
Why did you come in 2015? You should have come in 1994.
My lord.
Now suppose
what happened?
Suppose we allow it. There must have to be a recalculation of your salary every month from 1992. From 1992 to 2023, how many months are there? 30 years. 30 into 12 is?
I can understand that.
No, 30 into 12 is 360 months.
Yes.
Who will pay for that official who will have to do this work? Will you pay? One man has to be engaged to make all these recalculations. You personally pay for that man. Otherwise, why should you entertain all these petitions now after 30 years? See, had you come in 1994, it would have been very easy. It was a recalculation of only 2 years.
94 cannot, because, my lord, it was judicial notification, it was in 1998, my lord.
Okay,
Obviously,
1998.
thereafter they could come.
Very well.
But some similarly situated persons, they got the relief.
So there is a judgment of the Supreme Court, somebody waiting on the fence and watching others whether they get it or not. And once they get it, you come over. Those petitions are not to be entertained. Which judgment? Supreme Court? Some Mohapatra or something. Check up. It is there. What? No. What to do?
My lord, as senior
No, see the complications now.
Yes, yes.
Every month's salary for the last 30 years will have to be recalculated now. Why should we put that burden on them?
Otherwise, my lord,
You are happy from 1994, you are happy from 1998, whatever you are getting. Suddenly in 2015, you become unhappy. Come to the court. Then allow the petition to remain pending for another 10 years or 9 years now. And then say, please give me the order.
can you give me a date so that Lord may say all these things to senior counsel, because as he is engaged in this matter, my lord.
One senior counsel is also there.
Yes, you can.
adjourn with cost then 2015 matter. Pay cost.
Or adjournment, my lord.
See, if we are not a little strict, these things are getting out of control, Mr. You may not be liking what I am saying,
Yes, sir.
but sometimes words which are not very popular and not very liking, we are compelled to use to balance the system. See, firstly, you come to the court after almost 20 years, 18 years, 98, even if you take 98, 18 years. Then you allow the matter to go through for another 9 years. And today also you are not ready. You want further adjournment.
My lord, as he is engaged in this matter, that is why. Otherwise, my lord, I can go with this matter. No
From
issue.
your point of view, you are right. But from our point of view also, we have to look at from everything is not individual. I don't know. I am finding a little. I can grant you time, doesn't matter. But what will happen to this system ultimately? You tell me.
Maybe I should also blast on.
One day the burden will be so heavy, everything will crash. I'm telling you. If this kind of approaches are continued, and that too when we want to hear you. You argue? No, no adjournment. Please argue.
Yes, my lord, I can go.
Sorry, no. Firstly, you explain the delay, why we should not dismiss on the ground of an extreme delay, which will cause a grave inconvenience for the respondents to make a recalculation of the salary of every month for the last 30 years. This is number one. Secondly, on your entitlement, because apparently this is an ad hoc appointment. The page 17 says it's an ad hoc appointment. Why the ad hoc period should also be counted?
Yes, ma'am.
Why?
As per notification,
Which notification?
UGC notification, my lord.
Page number.
Page 27, my lord. Page 27. This is Annexure 6, my lord.
Which relevant clause?
Relevant page is my lord, page 31.
31.
Clause 8.0.0, my lord.
8.0.0.
May I read, my lord? Previous service, counting of past service, that previous service without any break as a lecturer or equivalent in a university, college, national laboratory.
What do you mean by previous service?
That previous service, my lord, ad hoc service, my lord. First, may come to the down part, my lord. It is clear.
Mr. Counsel, please come straight away. Don't take the circuitous way.
My lord, this
One you are selling
part
this.
is relevant,
See,
my lord.
one approach I did not like of yours. When I asked you what is the relevance, it required 3 questions to be put to you to come to the relevant page. Why you could not have said that I'm relying on this clause of this page straight away?
My lord, this
You could have done that.
entire part is relevant. This entire part is relevant, my lord.
Yes, argue.
Previous service without any break as a lecturer or equivalent in a university, college, national laboratory or other scientific organization, etc., and as a UGC research scientist should be counted for placement of lecturer in senior scale public selection grade, provided that the post was in an equivalent grade public scale of pay as the post of a lecturer. Number 2, the qualification for the post were not lower than the qualification prescribed by the UGC for the post of lecturer. Number 3, the candidates who apply for direct recruitment should apply through proportional. Number 4, the concerned lecturer possesses the minimum qualification prescribed by UGC.
Come to that 860B straight away.
860B.
Provided the incumbent was appointed on recommendation of duly constituted selection committee. Where is the recommendation of the duly selected committee?
For that, my lord, we have filed our reply, my lord.
Please take us through the recommendation of the duly considered selection committee.
Only that is
A recommendation, my lord. If recommendation is required, how a person can be appointed under regulation 3F?
Mr. Counsel, courts are not here to answer. Courts are here to give judgments, and it is for you to answer.
That point is I am raising this issue because, my lord, it is logical.
Go and raise it in the assembly. There you will get a reply, not in a court of law. But yes, your name.
My lordship is not hearing me the matter.
Then what are you doing? What you did for the last 15 minutes then?
My lord, I may be actually allowed to continue my argument.
See, your argument has concluded. You are required to produce the duly recommendation of the selection committee.
Duly
Mr. Gogoi
recommendation
says it is not there. And
court
what
is
more
going
you
according
want
to
to
him,
argue?
but court is not hearing me. Duly recommendation if it is required, recommendation of APSC. If it is required, how a person can be appointed under regulation 3F? Regulation 3F appointment is there. For emergency, it is appointed. Someone is appointed under regulation 3F and then pass ad hoc service, whether that period can be counted or that is the issue here, my lord. This judicial notification is very much clear, my lord.
Yes, we are hearing you. Continue.
Yes. That 8.5.
If necessary, all matters adjourned. We are going to hear you today. Yes. Continue. As long as you want.
The post was filled in accordance with the prescribed selection procedure as laid down by the university, state government, central government institutions.
What you are reading? Which page?
Page 31, my lord.
Same one. Okay, go on reading.
8.6.0. The appointment was not ad hoc or in a leave vacancy of less than 1 year duration. That is the very relevant part. If the ad hoc appointment is for less than 1 year period, then it is not to be counted. Ad hoc service of more than 1 year duration can be counted, provided the ad hoc service was of more than 1 year duration. That we fulfill. The incumbent was appointed on the recommendation of duly constituted selection committee. I'm coming to that. Next one is the incumbent was selected to the permanent post in continuation to the ad hoc service without any break. That we fulfill. That is the relevant part. What your lordship raised, that 8.6.0b. The incumbent was appointed on the recommendation of duly constituted selection committee. For that, what kind of recommendation is required? That, my lord, lordship may come to the my rejoinder, my lord. It starts from page 74, running page, my lord. Here relevant para is para 2, my lord. That the deponent begs to state that the petitioners in the instant writ petition in pursuance of an advertisement dated 8/9/1991 applied to the different post of lecturer in Cotton College, Guwahati on ad hoc basis for PG courses which were likely to be regularized pro APSC in due course. Accordingly, they were appointed under Regulation 3F, Assam Public Service Commission, Regulation 1951 by way of different appointment orders as annexed herein in the writ petition. So, type copy of the relevant portion of the advertisement. Advertisement is page 76, my lord, annex 1. That is, my lord, applications are invited from the citizens of India as defined in in the prescribed form of application available in Part 9 of Assam Gazette for following post of lecturer in Cotton College, Guwahati on ad hoc basis for PG courses which are likely to be regularized pro APSC in due course. It was the advertisement. Advertisement was there. Thereafter, my lord, we were selected and accordingly we were appointed under Regulation 3F. They are not saying that we were not appointed under Regulation 3F, my lord. Our appointment is not disputed, my lord. But whether that appointment was under due course or not, that was the issue, my lord, they have raised. But that is not an issue because the advertisement was there. As the advertisement was there, as our appointment was there, definitely there would have been selection, my lord. How after advertisement someone can be selected without, my lord, selection, my lord? So ultimately, my lord, we were appointed under Regulation 3F, and Regulation 3F appointment is such a type of appointment, my lord, that for emergency and for any urgency, my lord, under regulation TF, appointment can be done. And when that appointment period, the period under which under regulation TF, when that is for less than 1 year, my lord, that is not to be counted as per their judicial notification. But if it is more than 1 year, then it is to be counted, provided this part, and we fulfill that.
We
part.
have already repeated 3 times, same line.
Thereafter,
Same line
my lord,
repeated 3 times. Now, what more you have to say? Please say.
thereafter, my lord, what happened when we approach,
Don't repeat. Complete.
when we approach before the Assam Administrative Tribunal, that is at page 70, my lord. Page 70, my lord, and extra 18. When we approach before the Administrative Tribunal, may I read, my lord? Annex 18, my lord.
How do you know whether you want to read or not? It's up to you. You want to
Lordship,
want the court to be heard. Do anything you want. Up to you. Go arguing any way you feel like. If you want to read, you want to
page 70
not
and extra
read it.
18, my lord.
Page number?
Page number, my lord, 70 and extra 18. This was an order, my lord, passed by Assam Administrative Tribunal when we approached before the learned tribunal, my lord. It was order dated 21 to 2015. This appeal was taken up for hearing on the issue of admission on 7 to 2015. After hearing the learned counsel for the appellants, the bench had expressed a view that it was not inclined to admit the same. The learned counsel pleaded to be given another opportunity of being heard, for which it was taken up again today. The learned counsel for the appellant began with a request that
Mr. Counsel, you are here to make submissions, not read the entire pleadings, whatever it is there. Please make your submission. What? We can't allow you to waste time. Others' time. Make your submission what you want to make out from that order.
yes, my lord. Page 71, my lord. Third paragraph, my lord. We have strong reservation for the judgment dated 14/8/2012 because of it was an order by which, my lord, some similarly situated candidates were allowed that benefit, my lord, because of which we are not inclined to enter in this application. In the said judgment, this tribunal has held that the date of appointment should be deemed to be the date of appointment under regulation TF, and that the benefit of this service should be counted for the purposes of seniority to make the personnel eligible for upgradation to senior skill and selection grade by taking into account the service rendered by the person as an ad hoc appointee appointed under said regulation. In arriving at this conclusion, the tribunal has quoted a ruling of the apex court in civil appeal number so and so so and so. In this, the Honorable Supreme Court has held that the government is not right in making a departure from the rudiments of the scheme recommended by the UGC for conferment of higher scale of pay to lecturers to devise a new mechanism. They have quoted clause 8 of the UGC notification laying down the guidelines pertaining to counting of past ad hoc service for the conferment of senior scale and selection grade to the lecturers. And tribunal has concluded that the lecturers fulfill the conditions laid down by this clause, and the government was not right in making a departure. This interpretation is not correct, as subclause F of clause 8.6.0 as quoted in the said order of the tribunal stipulates the following condition. The 8.6.0, the incumbent was appointed on the recommendation of duly constituted selection committee. Here, the words use the duly constituted selection committee. Duly constituted would mean constituted as per rules laid down for the selection of lecturer. The rules laid down that the selection of lecturers would be done by APSC. The duly constituted selection committee would therefore be a committee that has been constituted for this purpose by the APSC. It means that they are referring directly APSC for selection. So APSC would definitely refer, APSC would definitely recommend, but later on, not at the time of appointment under regulation TF. The duly constituted selection committee would therefore be a committee that has been constituted for this purpose by the APSC. All these appointments.
Mr. Counsel, please make your submission. Why the tribunal view is wrong? Only raising question why and will it not lead you anywhere?
That is also one, my lord, what I have raised.
You are a very difficult customer, Mr. Gogoi.
Gogoi.
What's your name?
PK Das,
Mr. Das, yes. Please make your submission, cooperate to the court so that we can arrive at some conclusion against you. If you are taking up an ego issue,
no, my lord,
it's you can go. Others will suffer. We'll hear this matter for the whole day. Yes, we'll come back and hear you. Take it to be a good enough for the day. Yeah. We'll hear Mr. Das today in its entirety because he is not cooperating. A simple question we're asking you for the last 15 minutes. UCSC regulation says that if the ad hoc appointment is beyond 1 year, it should be also supported by a selection by a duly constituted committee. Was your selection made by any duly constituted committee?
Yes.
Where is the committee recommendation? Let us see.
Committee
You are
recommendation,
saying all thing else other than also putting blame on the court. We are not hearing you, but you are not ready to answer. As long as you don't answer, it will not lead you anywhere.
My lord,
You
advertisement.
can consume time, but maximum you
It
can do
was of
that.
my lord 1991. There,
Sorry?
1991, my lord, advertisement. Thereafter,
Mr. Counsel, advertisement is an invitation for application. That doesn't mean that it is being selected by a duly selection committee.
but duly selection committee doesn't mean that it is APSC, my lord. According to this tribunal judgment, my lord, it is APSC.
Okay, tribunal is wrong, it is APSC, but duly constituted selection committee under which rule then? See? And was any committee there in your case? Mr. Gogoi says no. Mr. Gogoi from the record says that there is no such committee.
Then Mr. Gogoi can submit the entire record whether we were selected or not.
Yes, Mr.
See,
Gogoi, what manner this man was appointed?
It is governed by 1982 rules.
Hmm.
He is a purely TF appointee.
Understand.
And 1982 rules.
See, 1992, he was appointed under 3F, that is an ad hoc appointment.
Lordship.
Question is whether that ad hoc period should be counted towards his service for the purpose of this scale he is claiming for.
Lordship.
He refers to a UGC regulation saying that ad hoc period can also be counted if it is more than 2 years, provided one of the condition the man is selected by a duly constituted committee. Was this man selected by a duly constituted committee? This is the fact we want to know.
No, Lord.
Because he is not answering.
No, Lord. Even Lordship, my Lord, may for a moment kindly peruse 7, 10.
No, not required also to go
Then
anywhere.
rule also says that, Lordship. Rule so in Lordship permit I can read
7,
just
10
one.
of what?
Lordship, the Assam Education Service to 1982, Lordship. Lordship, I point out 2 lines, Lordship. The period of appointment under APSC limitation and of functions regulation before regularization for commission shall always be ignored for the purpose of determining seniority.
Sorry, please repeat.
Lordship, the period of appointment under APSC limitation of functions regulation before regularization through commission shall always be ignored for the purpose of determining seniority.
We'll hear your reply on these two. We'll come back.
Yes, madam.
And we will not allow you to just go and saying anything, whatever you feel like. Huh? Give a specific reply to.
My lord, I have the specific reply. What rule he is, my lord, submitting, laying before the honorable court, my lord. That is of 1982. And this UGC because it was of 1998, my lord. We are covered under this. How can he say that rule is not covering us for this benefit, my lord? That is the difficulty, my lord. Government is ready to comply the UGC notification, not in full, but in half. That one judgment of the Honorable High Court of this Honorable High Court is also here, my lord, with me as an examiner.
Are you seriously arguing, or you are just are you seriously raising any legal issue, or you are just making some complaint against the court and against the government and all?
No other.
Please come to terms, Mr. You are a responsible lawyer, mind you. You are supposed to be a learned counsel
Yes.
and respond in the required manner. See, lawyer argues a matter. What is the meaning of the word argument? Take out the dictionary and find out. It has two clear meanings. One, heated exchange of words. Second, a logical presentation of a matter. Argument by lawyer is the second meaning, not the first one. First one is outside on the street. So logically, please say, a serious legal issue has come up. You are taking the brief of a person. Rules referred by Mr. Gogoi, you say it is not applicable. Although you are in the Assam Education Service, you say that rule is not applicable. I don't know why. Just a minute. Two, you refer to UGC. UGC also says that in the case of your kind, it has to be selection by a duly constituted committee. We are asking only one question for the last half an hour. Where you selected? Your answer is everything else other than the question put. Mr. Gogoi says from the records that you were not selected.
Which record, my lord, that can be produced before the honorable court, my lord?
So you are disbelieving Mr. Gogoi's statement. On what ground?
Making just a statement, my lord. He is not producing the record. On what basis we were appointed?
File an affidavit. Mr. P.K. Das, Learned Counsel for Petitioner, disputes the statement made by Mr. K. Gogoi, Learned Counsel for Higher Education Department, based on record that the petitioner was not selected by a duly constituted committee. The basis of such dispute be made available to the court by way of an affidavit this tomorrow. Yes, earlier order 16.5, therefore
Yes.
it will be relevant to ask the authority of Dibrugarh University to produce the record.
My lord, actually what had happened, in their affidavit, they took 2-3 grounds why I was not invited. Now then, my lord, I
This
made
is a
all
case for
the-
appointment.
Yes, my lord.
Advertisement, not call for the thing.
Yes.
The university record is required as because lordship the interview is conducted by the university lordship. For the post of principal of a particular college lordship. AC as a chairman lordship.
And the appointment's already made.
No, there is a stay.
Stay, still a stay.
Yes.
Stay, we are also supplying lordship, we need regular principal.
No, we'll hear you.
Lordship. So lordship, the record is necessary, otherwise university record.
Is the Dibrugarh University a party to the
Party
proceeding?
here.
If they are not party, they are not come.
Party here and Mr. Mozumdar is also appear lordship.
No, if they are not a respondent,
No, the selection committee we have made the party.
Party is
selection committee is a
Yeah,
part of
yes,
Dibrugarh
yes,
University.
yes, yes. Represented by chairman. Yes.
Who represents the selection committee?
Lordship, R. Mozumdar, today he is.
Where is he?
Today is not available. Today he is not available, lordship.
They only doubted one of my certificate. That we have given original, they asked for. Every time they are filing in affidavit, they are coming up with new grounds.
They means university or
The governing body of the college, my lord.
who represents a governing body?
Lordship, he says that lordship he is suffering from fever.
No. Who appears for the governing body?
For the governing.
You appear. Who had constituted the selection committee, governing body?
By the university. Dibrugarh University at page 70.
Why is it constituted by the Dibrugarh University?
My lord, to evaluate the API score. Academic API
No.
score.
I think
No, the rule is amended, lordship. Rule is amended in case of earlier it was by the governing body, lordship. After amendment of 2010 rules, lordship, the committee.
Mr. Gogoi, I think I have dealt with this matter.
The interim order was passed by lordship, my lord.
This one, no, I have.
Recently, my lord.
I think about maybe 1 or 2 years back. Under the rules, the selection is by the governing body. Okay. For the purpose of some evaluation, some API evaluation, it is the university.
My lord, API is not even an issue here.
It's not an
Here,
issue.
here only issue is, my lord, my certificate.
No.
And my
The
doctorate.
one we held is that.
Okay, in that case.
By requiring the API evaluation to be done by the university cannot substitute itself to be the selecting committee.
Selection authority.
They are there only for a particular purpose of evaluating the API
API
score.
score.
They evaluate it
And give it to the
give it to the.
It is in respect of Bilasipara College, Lordship.
I think so.
Bilasipara College. Regarding API. But Lordship, here case is there, Lordship.
So API
is not issue, Lordship.
Because of API, university we are not concerned unless the university, while evaluating the API, had done some illegality.
API is not here the issue.
Then
Lordship, here, Lordship, after amendment of the 2010 rules, Lordship, the selection of the principal committee is constituted by the Lordship university. Lordship. Earlier it was governing body, Lordship. Although in the new book, the amendment part is not there, it was amended in 2021 itself. It is not incorporated in the new
But it's a
book.
selection prior to that. It's a selection of
No.
2018. Oh, that's a rules. But it's a selection of 2018.
No, I understand. Let us see the rules, what you are referring.
Rules, Lordship, today I am not being amendment part.
But you don't have the rules.
Otherwise, it was amended. After going through the books, I've seen that it was not incorporated.
Achha, now the selection committee will be constituted by the university after 2021.
Before that, Lordship, probably Lordship 20 or 19, Lord.
No, but
But this one is of clearly of 18 because the repetition is of 18. It cannot be of 19.
Yes. That provision will not come. In their affidavit, they have clearly stated why I was not called. Now, when we meet that, they are now coming up with every day they are filing affidavit and they are changing the goalpost.
Okay, let us hear.
Yes.
From the beginning. Who is Gurunath Sharma again? Respondent number 5. Implemented as done by order, court order dated.
He has been selected.
No, they say selection is yet to take place.
My Lord, Lordship has stated that no further, no appointments to be made.
But are you required to hear him?
I think somebody appeared, my Lord.
No, are we required to hear you? See, if we dismiss this petition, one legal right will come to you on the basis of your selection. If you allow this petition, the selection may be redone. Okay. But what kind of a legal right you have being selected in the meantime to oppose the legal right that he is espousing? You don't have any right to reply to that.
My only claim is, my Lord, my case should be considered. Whether I'm selected or not, that's a different issue.
No. The reason for why it is not considered, even if we hold it in your favor, a subsequently selected candidate can have no legal right to oppose to that.
Yes.
So why should we hear you number 5? Yours, if you're not liking what you are saying, there is a judgment of the Supreme Court on the issue of necessary party. A person who is a consequential beneficiary of any action, which is the subject matter of a litigation, is not a necessary party. From that point of view, possibly, I've forgotten the name.
63, my Lord.
Maybe it's a old 60s, 70s. Consequential benefit, you are only a consequential beneficiary. That ultimately, without him, in the selection, you are selected. So I don't think we are required to hear you. Sorry. Let us see whether records are required or not.
Yes, yes.
Let us begin the hearing.
My Lord will kindly come to the writ petition, my Lord. With the, my Lord, if I wouldn't have had those qualifications, I could not have become associate professor. Please come to my Lord, page number 16.
60.
16, my Lord, of the writ petition. On the recommendation of the Departmental Promotion Committee and governing body's resolution number so-and-so of the Dhammarji Commerce College, selection grade scale of pay in respect of the following assistant associate professor are hereby allowed with effect from the dates shown against their name. Name, Shankar Patwari, that's the petitioner, my lord, Department of English, with effect from so. So, my lord, I was given the benefit of, my lord, associate professor. Then, my lord, the advertisement is at page 18. There was an earlier advertisement of 2015, then again it was advertised. Application with complete biodata and supporting testimonial.
Mr. Can we have just a gist of the matter so that I can start thinking in what is required?
The simple matter is the post of principal of the college was
okay,
advertised.
Post of principal.
Yes, principal. I am an associate professor.
You are one of the intending candidates.
I am one of the intending candidates. Then, my lord, they by page 19, 3 documents were asked for. Please come to page 19.
For this purpose, 3
Yes.
documents were asked for.
Yes.
Okay. Original copy of the certificate, mark sheets,
Yes.
MA, previous final.
PhD awarded notification and document of research guideship.
Bundelkhand.
Yes.
Your MA is from Bundelkhand.
Bundelkhand.
Okay.
Then, my lord, will kindly come to page 20.
PhD awarded notification, documents of research guideship.
All I have given, my lord. In spite of that, my lord, my case candidature was not considered.
The principal submission of. Okay, you have submitted original mark sheet dated PhD, original research, copy of the court affidavit. As mentioned, why court affidavit?
Because that was asked for, my lord. That was asked for.
Affidavit also asked.
Yes.
And now?
Now, my lord, will kindly come to the affidavit filed by the governing body.
Page number?
Yes. Page 28. Running page, my lord. Para 7. That the deponent states that the meeting of this screening committee was held on 13/3/2018 at Dibrugarh University for screening of API of the applicant for principal of the Dhemaji Commerce College, wide advertisement it is so and so. The committee scrutinized the applications of the applicants and after
now Shankar Patwari we have read was not found suitable, non-fulfillment of required eligibility criteria.
Yes, kindly see, my lord, though they started with API, now they come to this. The reason mentioned for non-recommending candidature of writ petition are PhD certificate not found, already given, my lord.
Page number?
Page 28, my lord. Running page 28. Paragraph 7 of the affidavit filed by the governing body.
28. Running page 52.
28, my lord. My lord, affidavit page, internal page 4 of the governing body's affidavit.
Is it this page? That is also some page 28.
My file has the pages, I do not.
I think nowadays we have put this running page number. If the running page number is
28.
Same page.
Same. No, some.
Oh. A2 28, A2 28. Acha, A2 running page.
Yes. I will kindly have para 7. That the deponent states that the meeting of the screening committee was held on 13/3/2018 at Dibrugarh University for screening of API of the applicants for principal of Dhemaji Commerce College, wide advertisement dated 18/1/18. The committee scrutinized the applications of the applicants and after thorough examining the application and documents submitted by candidates, found 2 applicants suitable to be called for interview, and candidature of the writ petitioners not found suitable due to non-fulfillment of the requisite eligibility criteria. The reason mentioned for non-recommending the candidature of writ petitioner: PhD certificate not found, PhD notification not found, MA certificate from Bundelkhand found, but mark sheet of MA previous is computer type, whereas final mark sheet is handwritten. The logo of the university also not found on the mark sheet of the previous year. PhD pre-registration course were completed in 2013. This is also submitted in 2013 as per documents submitted by written. So these are the 4 reasons, my lord, why my candidature was not considered.
From where did you get it? The reason mentioned PhD not found?
Page 28, last sentence, my
No,
lord.
no, no. This is your pleading.
No, this is the pleading of the governing body.
Achha, pleading of the governing body.
Yes.
Okay. Ha, ha.
The reason mentioned for non-recommending the candidature of
And what is this other page 28? That became Annexure C. Running page 52 possibly.
Okay. This is same thing, my lord. This is
No, but here where is it mentioned?
meeting of this.
All these that the reasons PhD not found, is not found. Where is it mentioned? It is mentioned only candidature was not found.
They say, my lord, to put the observation in detail on the body of the calculation sheet of API.
So where is it? So this must be by the
page 55, my lord.
55.
Yes. Reasons.
Page 55. Reasons.
Page 55, internal page 31. PhD certificate not found.
Okay. Performance-based appraisal.
It's a continuation, my lord.
I understand. Reason.
PhD notification also not found. MA certificate from Bundelkhand found, but the mark sheet of MA previous from Bundelkhand University is computer type.
Found, but mark sheet of MA is computer type, whereas final mark sheet is
handwritten. The logo of the university also not found on the mark sheet of the previous year. PhD pre-registration course were completed.
Are these available as annex?
Yes, my lord, everything.
Which page?
In a reply, we have annexed everything, my lord. Please come to, my lord, page 117.
Who represents the college? You represent the college. Where are your records?
I have.
You say PhD not found. Let us see whether PhD is there or not.
Please come to 117, my lord. In the writ petition, page 20, I have already submitted those documents when it was asked for. Page 117.
So this is computer generated.
Yes, my lord.
This is for previous.
Then, my lord, will be 118. This is the final one. They say logo is missing. Logo is there, my lord.
Just a minute.
MA Final English, Shankar Patwari, Bundelkhand College, Jhansi, UP. And they confirmed from the university also, my lord. That letter.
Why Bundelkhand is giving like this? In one exam they will give computer, next one they will give.
That we don't know.
Bundelkhand specialty.
Yes, and in fact they confirmed from university also. University also confirmed.
Confirmed that it
yes,
is
yes, yes. It is there. Then my lord will kindly come to page 119. This is regarding that my
certificate,
lord.
that PhD.
This is the money receipt, my lord.
119 is statement of marks.
Yes. Then my lord will kindly come to page 121. Guwahati University, award of degree of Doctor of Philosophy. The undermentioned candidates are declared to have qualified for award of degree of Doctor of Philosophy as per Vice Chancellor's approval dated 1/7/14 and serial number at page 122, my lord.
122. Shankar Patwari.
Shankar Patwari. 32/3437. And page 123 is this certificate.
So just a minute.
Now, my lord, if your lordships kindly comes to page 134, that's the clarification by the university, my lord.
No, no. One more
they wrote.
No, just a minute. One more respect. If a degree is awarded by a university, this is what we wanted to look in the other matter in the morning. What authority remains with a college authority not to accept it? Degrees are given under the UGC Act by the universities.
Yes.
So if it is genuinely given, if you say it is fraud, we understand.
Yes.
That these were never given, you have just brought a piece of paper,
As a fabricated document or something like that.
But in what manner the degree was given, how can a college authority question the
Question it,
university? Do you have any authority under the law to question it?
No.
Then, if it is there, you accept it.
Well, page 134.
If you have doubts, you write to the university.
Yes.
That
But
one
they wrote
person
to the
has,
university, in reply, page 134.
even that is also not required. You are bound by certificate. If every authority today starts questioning, what will happen?
There will be no end to it.
In the morning, I raised one question. Suppose the bar council says somebody comes to become a lawyer with a law degree, starts questioning the degree. You have obtained the degree in this manner, that manner, all kind of things. Can you do it? Possibly no.
Page 134 may be seen, my lord. Now, university, the original is in Hindi. We have given the translated copy at page 134.
Your PhD is also from some other university.
No, what university? That I have already shown at page 123.
No, you said Hindi. That's why.
No, Hindi is that clarification from the university.
The Budelkhands.
Yes. That's part of the additional affidavit, my lord, at page 134. It's a communication dated 14/9/2018.
The relevant page?
Page 134, my lord, that annexure.
No, 134 is the beginning. 134 is the first page of an affidavit, additional affidavit.
Yes. Or maybe, my lord, lordship will kindly have a look at page number para 5.
Of this affidavit.
Yes, that the respondent number 3, whether it starts like that, my lord. That the respondent number 3, by their affidavit in opposition, have stated that petitioner's candidature was not recommended due to the reason, amongst others, doubt arose regarding MA certificate from the Bundelkhand University, as MA mark sheet of MA previous is computer type, whereas final mark sheet is handwritten. The logo of the university also not found on the mark sheet of the previous year. The petitioner humbly begs to state that principal in charge and secretary of the Dharmaji Commerce College, while later dated, had written to Bundelkhand University regarding enrollment of the petitioner in MA course. In pursuant to the same, Bundelkhand
Bundelkhand is an
University.
approved university under the UGC.
Yes.
They have, UGC has no difficulty.
No. They had some doubt, my lord. They wanted to clarify, satisfy themselves. And university replied. In pursuant to the same, Bundelkhand University replied to the said letter by communication affirming enrollment of petitioner in MA English batch of so-and-so. This affirms the fact that petitioner was enrolled in MA English course in the year 97, and conversely came of the respondent number 3 that postgraduate certificate of petitioner is not genuine. This aspect has been suppressed by the respondents in their affidavit. They have not brought out this in their affidavit. And the internal page 7, my lord, of that additional affidavit is that letter.
Yes, who appears for the...
Now, this is the case, my lord. Now they are denying us.
Yes, Mr. Boro, I think you'll have to respond.
I am appearing from governing body, respondent 3, my lord.
So, who had issued this page 55 and
It's by the
page 52? I think it's by the governing body only.
Screening committee constituted by university, constituting of expert.
Oh, now we have to go back to the university again.
Lordship has just indicated, I'm sorry, my lord, that their duty is to find out the API score. They had no business to do all these things, my lord.
Nothing.
That's what precisely Lordship has said in the other case.
One judgment was asked.
Yes.
Mr. Gogoi may be having the reference.
I think he referred to the name of that college also, Bilasipara.
Last year or last year.
My lord, page 51, of our affidavit. That is the constitution of committee, page 51. 51 of our respondentary affidavit.
No, this is for calculation of APA scores.
Yes, my lord. That was the as per the advertisement, my lord. Page 49, my lord. Your lordship will
I
see
think
as
we'll
per
have to
the
make Dibrugarh University a party, it appears.
My lord.
They have to make Dibrugarh University a respondent. Otherwise, they will never come.
But that selection committee is there, my lord. And this is respondent number
Selection
4, my
committee
lord.
is there. And somebody appears. Oh, again, Muzumdar. Muzumdar is
Muzumdar
having
appears.
fever today. Somebody said fever. I think we'll have to interfere with this one, it appears. I was thinking if I can skip that one.
But we have made selection committee a party, my lord.
I understand. So I think their API things should be interfered.
Yes, they should only
Send
confine
it
to
back
API.
to that committee, redo it by taking note of that you cannot reject in this manner.
Yes.
And once you redo it, give it to the selection committee and you will complete the process.
Yes.
And in the meantime, your selection will remain as it is. If the other man gets selected over you, he will get it. If you get selected over him, you retain it. Otherwise, we are not required to hear you, I think. Yeah, law is quite clear in this thing. Otherwise,
The only thing is that, my lord, if I can submit, my lord, if it is, my lord, sent back, then the API score has to be reworked. Because they have
no, they have not given any API score. Just see.
No, API was never an issue, my lord.
Because
see, university committee is constituted to give the API score.
Yes.
Come to page
yes, correct.
52, not 52, in fact, it will be 55, I think. 56, that handwritten one.
Yes.
They have not given anything. What are they required to do?
As per the
Their requirement is on the various subcategories. What is the API claimed? Who will fill up this one?
My lord.
API claimed. Claimed, who will fill up? The candidate or?
Candidate.
He'll fill up. So you take the claimed API score of the candidate.
Also, kindly have a look at page 52, first sentence, my lord. What was the role of the committee? Meeting of the screening committee held at so-and-so for screening API of the applicant.
It's there in page 51 also.
Yes.
Committee constituted for calculation of API
That's
score.
all.
It's not for any other
Not for any other purpose.
And then API claimed will be there, and then the API score for verification. Committee will only verify the documents and give their API score.
Yes. Now, apart from that, my lord, if I can submit, my lord, as per advertisement, minimum API score is 40%.
Understand?
Yes.
What they can do is, based on these documents, they can give a low API score.
Yes.
But they cannot say not recommended.
Not
that your certificate is so-and-so, that so-and-so.
You don't have the
power,
authority to recommend or not to recommend.
That is by university.
Their authority is only to give the APS score. You may give APS score 0 also if you want. If your evaluation
or
says,
if I'm claiming, say, X, whether it is correct or wrong. That's all.
Now, my lord, another thing is that, my lord, after this.
Just go through this judgment. I don't know whether it will be of your help
But I'll
or
go through
no.
it, my lord. Yes, yes. I'll take the number, my lord.
There also we send it back to the Guwahati University for a necessary assessment.
We'll find out. Get it to the man. We'll get it.
this one may be in a little different line.
Context.
Just possibly. Just check up. Please check out whether we dealt with it.
I'll go.
The role of this API committee.
I'll go through it.
And you records we don't need.
I don't think records is
I think
necessary.
only we'll interpret page 52 and page 55,
Yes.
whether they could have done that or they could not have done that.
Whether they should have confined themselves to finding out the correct API score, or they
Firstly,
could have
API,
traveled
and
beyond that.
secondly, whether a duly issued PhD certificate can be rejected.
Yes. Or PhD for any degree certificate or post degree.
In fact, any degree can be rejected by any other authority.
My lord, most importantly, the college authority verified from the university that they have suppressed.
Maximum what you can do, we feel, is suppose the credibility of a given university is little less. It cannot be I reject that degree, but you can give some less APS score for that degree.
Yes.
Suppose Delhi University, you give them 8. Another
Of course, my lord.
easygoing university, you can give 6. But you cannot say that
Altogether
I'm rejecting it. Possibly you can't do that.
Another thing, my lord, as per the advertisement, the last date was on 2nd of February. So that is the date when the qualification should stand, my lord. Now this was submitted in the month of March, my lord. PhD and other things.
No. When did you obtain? What is the date of the certificate?
Already there.
It was before the cutoff date or
Before
after
the
cutoff
cutoff
date?
date.
Then it doesn't matter.
As per the read petition, my lord, page 20, it was submitted, my lord, on 19th of March.
Maybe submitted.
No, sir. 19th of March, I submitted because you sought clarification.
That is by the inserts principle. That is one disputed because as per the advertisement,
My lord, we all know in these small towns, my lord, they always have the man of their choice. They want to eliminate others. That's what they do, my lord.
Forget about that. Compassionate appointment, we are noticing it is there. First you select, then you reject.
So this API score, my lord, regarding this, they have to.
No, we don't have to go to that aspect because we are only limiting ourselves to the stage of API evaluation by the university constituted committee.
Yes.
If we interfere, it will go back to the committee for a re-evaluation of the API score. Once that is transmitted to the college selection authority, you take
Rest
all
of the selection will be carried forward.
the kind of objections you are raising, you take note of those. When can we have it? Mr. Mojumdar, when will be available?
Will it be next Thursday, my lord?
Tuesday, DBS. Thursday. Heard in part, list of further hearing. Upon hearing Mr. K. Chaudhary, and send a counsel for the petitioner, one of the issues for determination would be as to whether the committee constituted by the Vice Chancellor of Dibrugarh University for calculation of APA scores of the applicants for the post of Principal Dhemaji Commerce College also did have the jurisdiction to reject the PhD degree of the petitioner by arriving at the reason that the PhD pre-registration course completed in the year 2013 and the thesis was also submitted in the year 2013. In a circumstance where the university which had awarded the PhD degree had no difficulty with adopting any such procedure. Secondly, the MA certificates of the petitioner from Bundelkhand University were also found unacceptable by the API evaluating committee on the ground that the previous year, that the previous MA previous examination mark sheet was computerized, whereas the MA final mark sheet was
Handwritten.
In a circumstance where the university had clarified that both the mark sheets were generally issued by them. List for further hearing for the response of Mr. R. Mozumdar, Land Council appearing
On
for
Thursday.
the selection committee. List on switch.
My name may be replied for respondent.
Mr. Borua for the
Governing body.
governing body.
Item 29 for withdrawal.
Just withdraw.
My lord, with liberty, I seek liberty from this honorable court to withdraw the matter.
Your name appears.
My lord, P.R.
Your name, please.
P.R. Sharma.
Mr. P.R. Sharma, Land Council petitioner, states that there is an instruction from the writ petitioner not to pursue the writ petition in the present form with liberty to file the fresh. Writ petition stands closed on being withdrawn, liberty granted.
31 implement of party.
Implement in a writ petition.
Yes, my lord. My lord, I am for a petition, your lordship. I'll file objection in this.
So you are for a writ petitioner.
Yes, your lordship.
You want to object the implement.
Your lordship.
You want to file the affidavit.
Affidavit. Some time may be allowed.
She wants to object. Yeah. Heard Mr. S.B. Chaudhary, Land Council for
Another
the
IA, well, two IA. For both the IA. One is for implement, the second one is for vacating.
first the implement will come, only then the vacating will follow. Which is the one for implementing?
First one.
The number 2874.
Yes, my lord.
2874 likhbo, heard MSSB Chaudhary, Land Council for the applicant. It is stated that this interlocutory application for implementing the applicant as respondent number 7 in WPC 2042-2023. MS, your name?
A Begum.
A Begum, Land Council appearing for the writ petitioner intends to file an objection to the interlocutory application for implement. Pray aloud. Objection may be filed within 1 day.
2 weeks maybe.
2 weeks.
Well, short date, my lord. Only implement 1 week, my lord.
1
will be
week.
Sufficient. 1 week, I have some problem, your lordship.
You sort out the time, take it list on
11th October.
Next to the
11 of
32 for admission.
Yes, madam.
May it please your lordship.
Sorry, yeah.
Your lordship will this last occasion when your
I
lordship
think
had
we
the
heard
matter
it earlier, no? And issue has arisen whether teacher was only reaching English.
promotion to the in-charge principal, my lord, from the higher.
My lord, in the last occasion, respondent was directed to produce the school record. So,
You appear for the
Private
petitioner was a teacher in the ME school.
yes, my lord.
School got amalgamated.
My lord.
Now, whether you will be a graduate teacher in that amalgamated school.
Yes, graduate science teacher. And I have got the school routine, my lord, for the month of June, that he is, my lord, taking classes in the upper classes.
Mr. Sharma, can you ask Mr. Chisti or Mr. Kaushik, either of the two, I don't forgotten who had appeared. One day produced one notification before me regarding the status of a ME school teacher after amalgamation with a higher secondary school. We'll follow the notification. I think you need not decide it. It is already, government has already provided for that.
Yes, my lord. Notification is there. But
I think one notification, no, some 3-4 days back, somebody produced it before me. Are they available? Madam Phukon?
Sister sitting at the
Madam Ann Phukon? Is Mr. Chisti or Mr. Kaushik available? Just see.
he is not available. He is
Sorry?
out of station. He is out of station.
No, Mr. Chisti.
Chisti
If Mr. Chisti is there, I think he only produced it. No, Mr. Roy, and also again, before I hear you, if this issue is already notified by the government of Assam, we don't have to decide it. We'll only follow it. If it goes in favor of petitioner, it goes. In your favor, it goes. But if it is not there, definitely we'll hear both of you. But otherwise, it will be a futile attempt if they have already notified for it. Coming. Let him come. Oh, এটা বাজিলে
দুটা বজাত
নহয় নহয় মই যদি নহলে বেলেগ এটা মাতিলো হয় Mr. Chisti, whether it was you or Mr. Kaushik, I have forgotten.
Yes. It was Kaushik in this case.
One of, not in this case, one of you produced one notification.
Yes.
Or some OM or something, which gives the status of a ME school teacher after it is amalgamated with a high school or that higher secondary school.
Yes.
As to his status as a graduate teacher in the amalgamated school. A specific OM was there.
Yes.
Either it was you or Mr. Kaushik, one of you produced it before me. That must have been about 4 or 5 days back. It was the very মনত পৰে নেকি petitioner কোন আছিল
চাব লাগিব
It was Mr. Kaushik, I think.
মজুমদাৰ নহয় অলপ আৰচি লৈকে আছিল নেকি নহয় I think the same issue is involved in this case also. Petitioner is a ME school teacher.
Yes.
School got amalgamated.
Yes.
He is a teacher from the original high school. Both of them are trying for in charge headmaster or in charge principal.
Yes, sir.
If the petitioner can be constituted to be a graduate teacher, petitioner also comes in.
Yes, yes.
If the petitioner is not a graduate teacher, petitioner does not come in. So that notification will be of relevance, what had been provided.
Yes.
That will be 2 o'clock.
Maybe we can
That
sit
time?
at 2 o'clock.
I'll try to get it. Let it on Monday, Lordship. I'll try to
Monday?
get. Yes.
Okay.
Yes. Monday, more
Mr. Kaushik,
Yes.
there is a huge queue for listing the matters. We can't list it so frequently.
If he gets at 2, it's okay.
Yes, yes.
Otherwise,
At
when
2 o'clock, as it
otherwise,
is already in the list today,
Yes,
we
yes.
can take
let
note
it
of
come
it.
at 2.
I've forgotten who is the council. Because a lot of arguments were going on from both sides. Then the state produced one thing, and that all was decided. And if it is not there, we'll hear you.
Yes.
Suppose it is not there, then we'll have to hear on the basis of
Yes, yes.
whatever is submitted.
I'll try to get it, Lord.
For the college authority.
Sorry.
In item 12, Lordship.
Hey, Nas.
I failed to appear for the respondent on call.
I think it's fixed next week or
Yes,
something.
so only thing, Lordship, my presence may be marked
But
due to
no,
having-
Mr. Counsel,
Sign order.
how can you directly the court to take note of a non-existent circumstance?
subject to Lordship consideration.
Online হৈ গ'ল. It's already online. That's the difficulty of doing the work fast. Because in the lunch break, I complete all my first of work. But otherwise, I cannot accept that statement that mark my presence when you are absent, because you cannot ask the court to make a false statement. At the best, what I can do is you can delete that line that you are not present. Maximum I can do that. Don't write anything.
Lord, I'm sorry.
But you cannot ask the court to write a false statement.
Lord, I didn't mean this.
That I am not there, please write I am there. It will be
I didn't mean this.
fundamentally improper to do that. Maximum we can ask for it, please don't write this line at all. Then we'll ignore it.
Subject to Lord.
But difficulty is just check up. If it is online, we cannot help it anymore. If it is not online, then I'll take note of what you have said.
Item 32.
Did you find anything?
Regarding that,
No, one that I have read, but
this seniority, how to.
This is not the one.
Not that one. But that graduation part, that is not.
I don't know whether I'm right or wrong. Something is coming in the memory that.
Yes. And I couldn't connect with the B Kosek. He is out of station losses, so I couldn't verify from him also.
Take it up on some other day, this matter.
That will be better. Lord.
I think.
Yes.
Are you too pam niki more agudinor order to? To kuntu dilu to monot nai. Arsi sa ke nohoy. I'm unable to recollect the face of the lawyer also who appeared. Then it would have helped us. Not Arsi sa. No, what I remember, argument was going on, strong arguments from both sides. Then the government produced an OM, which provided for that only, and we accepted it. But and something to do with a ME school teacher after amalgamation of high school, what will happen to him as a graduate teacher? Something on that.
that is very relevant.
I think it will be here only. And if OM is there, we follow it. Whosoever favor it may go. And if it is not there, we'll hear you again from the court.
Let us fix on any other date, Lord.
Let's wait for list on
4th October.
Can be next week, my lord, because Lordship will remember. Lordship will remember.
Madam Sakya, I don't remember anything. That is difficult. And you take anything convenient, whatever.
Yes,
Whichever it is possible for.
Sub is a DBA.
Sorry.
26 DBA.
Sub 26.
26 there is a DB.
DB. 28 also DB.
Sorry,
And there is a long rush also for listing,
Yes,
what I have
my
been told.
But by the
And the
time
registry is having difficulty.
Pardon matter also, my lord, giving so long time, everything, my lord, we have to start again and again.
No, there's a lot of requests to the registry to get matters listed. What
Yes.
to do?
Once, my lord, just with due respect, I'm telling, my lord, some of the matters, when it is part hard, it should be at least 1 week or 10 days finish. Then, my lord, court also remember everything. But if it is gap of
Madam Sakya.
3 weeks, 4 weeks, my lord, then everything.
Madam Sakya,
Yes, my lord.
that is ideal, what you are suggesting.
Yes.
And ideal is utopia. Does utopia exist in this world? Utopia is everything is 100% perfect. That's the thing. We have to.
Yes, but it is not part hard. Other part hard matters on the field.
We have to work.
Yes.
way
Double
to
husband.
possible.
Hearing there, hearing.
Item 33.
33. Yes, 33.
Wednesday. Hearing.
First I get it.
And Phukan prays for 2 weeks' time.
Yes, Lordship.
PDAS, BTC, states respondent are not required to file any affidavit.
Your Lordship, here, Your Lordship, my part here mistake, Your Lordship, because it is BTR Kokrajar, Your Lordship. So, Your Lordship, Education Kokrajar, Your Lordship, Director of Education BTR. So, Your Lordship, here I would like to file affidavit, Your Lordship.
Then you have to file an application to get it recalled. Judicial order. Judicial orders are always permanent. And it can be disturbed only by another judicial order. Otherwise, the credibility of the court's orders will go down. That today you say not
I
required,
will
then again
obtain
say required.
instruction then, Your Lordship, required
No, no, if
instruction,
you
Your
want, you
Lordship.
can just file one paragraph application. We are ready to help you.
Yes.
But let the formality be completed. And then you will give it to file affidavit.
And Your Lordship, pertaining to SSA also, Your Lordship, I am appearing. Here also, Your Lordship, instruction awaited. Respondent need.
Today we don't pass any order. We just file an application to recall the order of 1929. That we have reconsidered the matter and of the view that an affidavit would be required. So kindly recall that order.
Yes, sir.
We'll do it. We'll allow you time.
Deeply obliged.
List again on 21.
Lordship, after 1 week.
Time like you.
Deeply obliged.
Time being item 7.
Sorry, October. Who is appearing for the state, for the government who appears? Mr. Pegu. You got that forensic? Because this is a very peculiar case we have found.
My lord, we are yet to receive that, my lord. And
But how long will you take? It's a 2016 matter.
My lord. Short take on 2 weeks, my lord. I'll get it, my lord.
See, your case is, his case is, he was recommended by the SLC. Your case is, he had informed you that he is doing some other work, does not require the appointment. Now he comes back to the court, says that, no, I need the appointment. And you have filed an affidavit stating that, bring you on record, the written communication by the petitioner that he is doing some other work, he does not need the appointment. He says, this letter was never written by me. Then we wanted to have the original of the application. Police says originally is not applicable, we have the photostat. Now what we do? Either I believe the respondents or I believe the petitioner. Had you got the original, matter would have been very easy.
Easy.
We can easily ask for his specimen signature, verify whether he had made that one or he had not made it. End of the matter. But you don't have the original. Once you don't have the original, Mr. Chaudhary will pounce on it. Say that, yes, I have told you I have not made anything. Therefore, you don't have.
Some accommodation for today, my lord, because otherwise, Dinar was looking after this case, my lord. Today he has some engagement.
So, if your photostat is there, forensic authorities can also verify from a photostat whether it is genuine or not. So, we required you to do that.
My lord.
It stated that the report of the forensic department is still not available. List on when?
After 2 weeks.
List on so and so, as paid for by Mr. G. Pegul and
Item 8.
But otherwise, Mr. Chaudhary, you'll also have to satisfy the court. Why did you wait from 2008? Because the recommendation was in 2008, SLC recommendation. I think it is 2008, check up. Why did you wait from 2008 up to 2016?
Various litigation, that is why, my lord. Several litigations going on thereafter. Review petition they have filed. Then I have filed reply. That is why the matter is delayed, your lord.
Mr. Chaudhary, did you understand the question we asked you? We asked you why writ petition filed in 2016, whereas the recommendation to appointees of 2008.
Earlier he was minor, my lord. That is why. He was minor.
Just a minute.
Minor.
You are in trouble. He was a minor. During which year he was a minor? In 2008. Then we let to interfere with the SLC recommendation. A minor could not have been recommended. That will go against this.
Yes, Supreme Court judgment of your lord.
Mr. Chaudhary,
On that day, your lordship will.
Mr. Chaudhary, you are also a lawyer with whom we have some difficulty, find difficulty. When you want to help you, ask you some question, you always say something different. Whatever is the question, you never answer, you always say something different. Court cannot progress in this manner. Either you cooperate or you don't cooperate. If you don't cooperate, we'll pass our orders. Please don't do that.
I shall cooperate in the court.
Please don't do it. Other day, that one PK does, same thing. You ask him something for his good, getting agitated. This habit will not lead you into any favorable order, because unless court has to give reasons for its order, we ask you questions to have the answer for the reasons. If you don't give it, if there is no reason, we will not pass any order. Next item.
Item 8.
My lord, regarding my lord, there is some area salaries and my regular pay scale. My
area salary regular pay scale.
my lord, page 47 of their affidavit in opposition, they have admitted that my lord, I have initially I was appointed as OBB teacher, Persian blackboard teacher, with a fixed pay scale of 1800 miles. And on acquiring the DLED degree, I am entitled to get full pay scale, my lord, which I have completed, my lord, on lordship 2019, my lord, 16/11/2019, my lord.
No, you are still a OBB teacher.
My lord. Yes.
Are you
OBB
still
teacher. Yes,
OBB teacher?
No, I am regular. I have regularized my lord.
Where is the order of regularization?
My lord.
Disposal.
My lord, page 3, my lord. Page 30 of writ petition.
Sure. Mr. Pegu, you accept that he was regularized?
Yes, my
Page
lord. There
30.
is a speaking order, my lord. After filing of affidavit, my lord, there's a petitioner have claimed for arrears, my lord. That
No, just a minute. Your area salary for which period?
My lord. Page 16, my lord, from 1/7/2004 to 22/7/2010, my lord. And one
No, salary on a regular scale of pay.
no, a fixed pay scale of 1800, my lord.
As OBB teacher.
OBB, yes, sir.
You were not even paid as a OBB teacher.
No, only for this particular 2 period, my lord.
You're not paid.
Not paid.
my lord, kindly look after the.
And on this issue, my lord,
Speaking order, my lord.
Oh, what is your stand? Is he entitled or is not entitled?
Not entitled, my lord.
Why?
Whatever he entitled has been already paid.
That
As
is
per
a
speaking
vague-
order, my lord. He was
Mr.
absent during this period.
During
So
the
no
period
work,
claimed
no
for, he was absent.
Yes, ma'am.
Yes, if you are absent,
No, my lord.
you were not absent.
He is, not correctly. My lord. By virtue of this honorable court's order, my lord, earlier I filed 2-3 writ petition, my lord, and by virtue of court's interference, my service was regularized, my lord. And kindly have a look, my lord, the order of this honorable court, my lord, page operative part, my lord, page 29, my lord, of my writ petition. Paragraph 18. In the result, the writ petition is allowed directing the commissioner and secretary to the government of Assam, Dispur and Director of Elementary Education to reinstate the petitioner within 8 weeks from today in the post of assistant teacher so by adjusting, regularizing his post in terms of communication dated 23/7/10, wherein the teachers appointed in the year 2001 along with petitioner under OBB scheme has been adjusted, regularized, being similarly situated. On his reinstatement in his usual scale of pay.
Mr. Pegu, why did you pass this order when the writ petition is pending? Did the court ask you to pass any order?
That instruction is not.
No. He had filed a writ petition, 2542/2020.
Yes.
We'll have to decide it. So now you write Honorable High Court case number 2542/2020.
So for my lord,
Did the director had undertaken the responsibility of High Court to decide this writ petition? Then why did you pass this order?
My lord, in our affidavit, the remaining claim.
Forget about
was not
your
decided,
affidavit. Have you understood what we are
Yes,
asking you?
my lord.
Somebody comes and files a writ petition
Yes.
on whatever grievance.
Yes.
Writ petition is pending.
Yes, sir.
Why did the director decide what has to be done in the writ petition? Unless the court by some earlier order had required the director to look into the issue, find out if there is any order, Mr. Don't you think it is unusual? Once a writ petition is there, matter is admitted, notice issued, you will file affidavit before the High Court.
Yes, sir.
You will not decide the writ petition. It appears that the director has decided the writ petition. Unless there is an interim order of the court that disposes of the writ petition or give him a hearing or something like that.
And here also, there is no reference to any court order.
No, the court order is not there.
Only the
Only writ petition. Whatever you have stated here, Mr. Tegu,
Yes.
could have been an affidavit before the High Court
Yes, sir.
depicting your stand.
Yes, sir.
It cannot be a order deciding
My
the
lord, I cannot.
writ petition. What are you doing? Who is advising the director in all this? Mr. Chisti, just take a look at this one order. You have a copy of this order. And in the end, you see, this order is issued in connection with Honorable High Court case number 2542.
The director should submit a report of it, not order. Because last
Director could have filed affidavit, director could have said their view that this is our submission. See, these are the facts, this is the law, this is my submission.
and not in this format.
Yes.
But the director appears to have already decided. Yes, now what do you have to say?
Now, my lord, another aspect, my lord, regarding my entitlement of regular pay scale, my lord. In their affidavit also.
No, first you tell me, what are your claims? What do you want? You want salary from 1/7/2004 to 22/7/2010.
10, my lord.
Okay.
My lord.
Why?
My lord, initially I was appointed.
No. Why do you want this salary?
My lord, these two periods, my lord. Other I was paid, my lord.
Sorry?
These two period only, my lord.
No, let us go period wise.
My lord.
Your first claim is 1/7/2004 to 22/7/2010. You want to payment of salary of 1,800 per month.
My lord.
Why?
My lord, I was appointed in the year 2001, my
Appointed.
my
Did you work?
my lord.
Were you working?
My lord.
Produce some material that you were working.
My lord.
How the court is to understand that you were working?
No, my lord, page 18 is the my lord. Order, my lord.
Page 18. But this is the appointment as a OBB teacher.
OBB teacher, my lord. And thereafter continued, my lord. What happened, my lord?
This is the word we are hearing. Thereafter continued.
My lord, continued.
Where is the material to show that you continued? Because the director's view, although the order may not be in a proper format, director's view is that you did not work. The respondents, Mr. Girin Pegul and Council of Elementary Education Department.
Ganesh Pegu.
Oh, sorry. Mr. Ganesh has produced an order dated 3/1/2023 of the Director of Elementary Education Assam, by which was in reference to writ petition 524/2020, that is the present writ petition, and accordingly concluded that the order was in connection with this the present writ petition, and by the said order, the claim of the petitioner for salaries had been rejected. In a pending writ petition, when there is no order from the court to either dispose of any writ petition or requiring the director to take any view on the claim made, we see no scope for the director to pass an order which may be an effective adjudication of the writ petition itself. But however, the contents of the order, from the content, it appears that it is the stand of the director. It is aware from the order. It is noticeable that the director has expressed the views as to why the petitioner is not entitled to salary paid for. The order dated so and so may be recalled by the director, and the views of the director may be filed in the form of an affidavit or before the court. 21. List on so and so.
My lord, I have another affair, my lord. I am entitled to get my regular pay scale from my lord 2019, my lord. From February 2021, I am getting my lord. And they themselves admitted in their affidavit.
We'll hear you when you hear the matter.
Page 47 of their affidavit in opposition, my lord.
Mr. Do you expect some 5-6 different separate judgments to be passed on different issues? We'll hear you on the same day, the day we have their views.
Right.
Item 14.
14. Adjourned on the prayer of Mr. U. Sharma. Ready?
Your Lordship directed to bring the UGC Act regarding MA degree.
UGC Act. UGC Act.
We have obtained MA degree for distance mode without hampering our normal duties. But director, by the order that it page 52, our degree has been ignored.
Act to support.
Regarding the manner of degree.
Your degree was rejected by
Yes,
somebody.
yes.
Who?
Director.
Page number?
Page number 52.
52.
1, 2, 3, 4, 4 paragraph.
Got it. Yes, right. For whom do you appear?
I am for responder for my lord.
Who is for?
Existing in academic interface. I am senior most teacher. Nurul Amin Ahmed.
I think Mr. Mukhtar appeared.
Yes, yes. And my actually in the hearing took place, my lord, in the hearing, my lord. If responder for
Now you say that you are functioning as the in charge.
academic in charge has been given to me as the senior most teacher, my lord. Section 22 কথা বলা Section 22, your lord.
22.
Lord.
Right to confer degree. Yes, Mr. U. Sharma. General clauses এখন আছে নেকি? General clauses এখন আছে নেকি? The 22 UGC Act. Do you have it with you? Or okay, get up and read it.
University, yes.
President. Read 22.2.
Yes.
What does it provide?
Save as provided in subsection 1, no person or authority shall confer or grant or hold himself or itself out as entitled to confer or grant any degree.
So only means that is through an university or a deemed university.
Yes.
Nobody else.
Yes.
Now, if you read section 21 of the General Clauses Act, what meaning will come out? The authority which is empowered to do something, that authority can modify, vary, or that act. Corollary to that will be any other authority will not be entitled to do it. Can you give that meaning?
Yes.
If you want to study more, you can adjourn it also. Because any degree under 22.2 of the UGC Act, it is only the university or the deemed university who can confer a degree. 21 General Clauses Act says that only the authority who is empowered to do that is the only authority who can vary or modify that.
Yes.
So not recognizing a degree is also modifying or varying that degree. As a corollary to 21 General Clauses Act, can any other authority be also empowered?
No.
See, I don't want to dictate the order today because it's a little complicated question of law. All of you just apply your mind, go through it. What kind of a meaning can we give? Mr. Mukhtar, you also go through it. Mr. Chisti, you can also look because this will have a little implication in many of your cases. Means the way we understand the law, whoever is empowered to do an act, only that authority can undo that act. Somebody else cannot say that that act is, that I don't accept that act. That act can be challenged in a court of law. Court of law can say that that act is arbitrary or illegal or whatever it is, declared to be this thing. But any other authority cannot say that I'll not follow it. Possibly that is the meaning. Please check up. So instead of rushing to it a judgment, just all of you please go to it and make the submission. While reading the order dated, impugn order dated 27/1/2023, it is noticed that the degree of in arts of 3 of the teachers, namely Johirul Islam Mullah, what Rahman?
Ghazi Rahman.
Qazi.
Ghazi
Rahman and Zakir Hussain Bapari obtained from Chhatrapati Sahuji Maharaj University, Kanpur, and Krishna Kanta Hendik State Open University, respectively, were unacceptable to the Director of Secondary Education, Assam, inasmuch as, while obtaining the said degrees, the teachers concerned did not obtain any prior information from the appointing authority, which, according to the Director, is a requirement of Rule 13 of the Assam Civil Services (Conduct Rules) 1965. In view of such stand of the Director, a question for determination would arise as to whether if a degree had been obtained by a person from a recognized university or deemed university, whether any other authority can declare that the degree is unacceptable in law. For a reason that there were certain procedural irregularity or violation of some other law while the degrees were obtained, as long as the university concerned who had offered the degree otherwise stands by the degree and are not of the view that the degrees offered by them are unacceptable. In this circumstance, a further corollary issue, arises as regards interpretation of Section 22(2) of the UGC Act, conjointly with Section 21 of the General Clauses Act, as to whether any other authority other than the authority who had issued the degree can amend, withdraw, or modify a degree to make it unacceptable in law. This count. for further hearing. Bring some more supporting material, whatever you give.
Item 18.
Yes, so why was it adjourned time being?
Well, I have read the office note, my lord.
Which office note?
Office
Oh, you
note.
did not read the office note.
Yes,
Yes,
I've
now
read
what
the
is your
office note.
submission?
Respondent number 2, my lord, has received the copy who is to comply the my lord order and has issued the follow-up hearing notice to us. We have got the copy. I have got it from the petitioner, my lord. Fixing the date on 26/9 of this
According
month.
to respondent who had received the notice.
Yes, they have issued the notice to us for conducting hearing.
What is the direction to conduct a hearing?
Yes, yes.
So we close the petition.
After, my lord, next date, my lord. After.
Why?
Because after conducting,
Why?
they have to pass the speaking order. They will take time again.
Why? There is no willful and deliberate violation.
And there is no willful
And this is not an execution case, nor it is a case that a Damocles sword will be on top of your head. Till you come in my terms, I'm going to hit you. Better close it. We'll give you liberty.
Yes, liberty will give.
Mr. B. Provider, this contempt petition is instituted alleging willful and deliberate violation of the order dated
22/7/2022.
22/7/2022. Page number.
And page number 10, my lord.
22/7/2022.
26/7, my lord.
22/6/7/2022 in WPC
5544.
55544/2021, wherein there was a direction to the writ petitioner to file a representation before the Director of Secondary Education Assam, and thereafter for the director to give a hearing to the petitioner, give a personal hearing to the petitioner and pass reason order after verification of the records. Alleging with deliberation of the requiring the forum. Although the notices upon respondents number 1 and 3 could not be served, but it is informed by Mr. B. Purokaisal and counsel for the petitioner that the Director of Secondary Education Assam has issued a notice to the petitioner
And
to appear before him for a hearing on to be held on 26/9/2023. As the director, in response to the order of the court dated, had required the petitioner to appear for a hearing, we are of the view that no willful and deliberate violation of the order is noticed at present. However, as provided in the order of 26/7/2022, the director to complete the proceeding of the hearing within a period of 1 month from the date of the appearance of the petitioner before the director, by doing the needful as provided in the order dated 26/7/2022 in WPC 5544/2021. Conduct petition accordingly closed. I think it's over.
Liberty.
Now what liberty? We're given a fixed date to complete.
26.
What is prayer of R. Mojumdar? R. Mojumdar is not well today. Yes. Did you read the file?
Yes.
What did you find?
Lordship, may I please, Lordship, the petitioner initially was engaged as a copyist in the district and session judge of Nalbari, and he was temporarily engaged, and with like his services was extended from time to time since 2011. On 2011, an advertisement was published by the presiding officer, page 39.
What was published?
An advertisement.
Advertisement.
Yes,
Okay.
page 39 and extra 12, where whereby for the appointment of office and various posts, and there was no mention of any qualification. There was no select for any procedure of qualification, but there was a mention of
Where is the advertisement? Which page?
an extra 12, page 39.
39. Okay, now?
Yes, and there was a mention that candidates having experience in judicial works or working in the judicial establishment which requisite qualification stated above shall be given due weightage.
Okay,
And
weightage.
yes. Then after thereafter, when it came to the notice of the petitioner about this advertisement, he went himself to the presiding officer to know about the procedure, but the presiding officer did not responded well. Then
No candidate has any right to go to the authorities. Now tell me what procedure you'll adopt. The right is not there with anyone. Go and appear in the examination. Whatever procedure they follow, you follow it.
Then
Not selecting the petitioner in the list of selected viva voce. What happened to the selection in the meantime? Is the selection over or there is an interim order?
There was a direction from this honorable court to proceed with the selection, Lordship, and
To?
subsequently that.
No, I didn't hear. To what the selection? To state a selection.
Initially, it was state, Lordship. Subsequently, there was a further direction modifying the earlier order.
To continue with it.
Continue with it, and the results were published, and appointments were also being made.
Results published after the court was informed.
Yes, Lordship. On Lordship Peru's order dated 8/1/2018.
8/1/2018.
Rule was issued, Lordship, and the
8/1/2018.
Yeah.
So, if you go by this advertisement, you are entitled to some kind of a weightage.
yes, even like
What do you understand by weightage?
like
In law,
some
not the general meaning of weightage. In law, what does it
some
mean?
beneficial, like some in accordance with experience.
Yes, where is the selection records of the selection? Did you give any weightage?
Lordship, in the written examination, he did not qualify,
But there was no mention of any.
and there was
No.
a resolution, Lordship.
No, where is the advertisement? What is the procedure for this thing?
Advertisement
Nothing is
is
there.
at page 39.
39.
There was
Any
the qualification prescribed was HS pass.
understand?
And there was nothing, Lordship.
No, applicant by posters who are found in or will call for written test. Written test is there.
Yes, Lordship.
Will we call for written test? That's the second clause. So now, just a minute. Now, at what stage will you give the weightage?
Lordship, subsequently, he approached this honorable court by filing WBC 1537 of 2012. Therein, the court was of the view that some weightage needs to be given since it was in the advertisement itself.
I understand. How will you give the weightage? And or at what stage will you give the weightage?
Lordship, in
There was
terms
no
of the
mention of
resolution adopted by the
Should not
committee.
interfere when
Yeah,
somebody
yeah,
is saying.
In terms of the resolution adopted by the committee, Lordship.
You
only
produce the records. The respondents to produce the records of the selection pursuant to the advertisement dated 13/12/2011, page 12, page 39, annexure 12 to the petition. This is a very, it will be an interesting question. How will you give the weightage now? After conducting the written test, then conducting viva voce, amongst the people who survives the written test, you will give weightage after that stage, or you will give the weightage in the beginning stage.
That needs to be determined. But otherwise, Lordship,
So, no.
Since the written examination was itself a qualifying one, Lordship.
Understand. So now, suppose somebody fails to qualify in the written test, what happens to his weightage? Will he not be entitled to the weightage? Then how do you intend to give weightage to that man and then see whether he qualifies or not? Now, understand what you are saying. A man did not get 50 in written test, got only 47, so he did not qualify the written test. You don't call him for the viva voce. Generally, yes. But for the weightage part, at what stage will you give the weightage? After the final selection. If he goes through all these tests, or weightage during the selection, because written test is a part of the selection.
Yes.
At what stage will you give the weightage?
There was a resolution, and
Mr.
it was-
Sharma, we understand you have everything. We are asking you a general question.
No.
Suppose a man did not get 50 in the written test. He is not qualified. He is out. But at the same time, you are also required to give him some weightage. So by ousting him, how did you give him the weightage?
That part
He
is
can
not-
be ousted only after giving the weightage.
No. I understand that.
I know. But how will you answer the question?
But from the records, Lordship,
We understand what you are saying. Man, you want in the written test 50 qualifying marks. You did not get 50. I did not call you for interview. You were out. So that's a very simple case you have stated. But in doing so, the respondents to submit that by ousting the petitioner for having secured 47 marks, where the cutoff mark was 50, in what manner the weightage that was required to be given as per the advertisement was given to the petitioner before ousting him. List on 21. 21. And who are they? These copies?
Yes, copies.
They are given salary.
Yes.
Suppose they are appointed, are they given salary, or they are, every person is professionally paying them?
They were given salary, Lordship.
By whom?
By the this establishment, Lordship. MSCTS.
Regular post.
It's a regular post. Regular post with salary. মানে এই professional engagement নহয় মানে per case ইমান পইচা
MSCT.
Item 2 and 4. What is
এই মেডিকেল রুলস কোন সব
rules গুলা দিয়া আছে
রুলস খিনি ক'ত এখন নেকি এখন পাইছো হয়
Lordship has already seen the rules, my lord, and we were on 8C basically. So our submission was that, my lord, A and B.
Go ahead. I remember your submission.
Yes. And
Your submission is second proviso to be read independently without anything else.
no, my lord, not independently. My,
and you always say no, but you never say the yes.
Lord,
Then what is the yes?
No, my lord, I have always said.
And mind you, we are not giving a long hearing. We have already heard about 7-8 days till now.
Yes, has heard, and the judgments I would.
So now, what is your submission in one sentence?
My submission
in one
is
sentence.
that the second proviso is an exception, which is necessary, my lord, because without the second proviso,
Understands. Second proviso is an
carve something out.
Is an exception, means it has to be read independently.
Yes, to that extent.
You are using a different word. I am using a different word, but you are saying the word no.
Because, my lord, as far as the reserve.
Because unless I understand you, I can never dictate any order. So you better come to terms and.
Yes, my lord, the reserve category candidates are covered under the second proviso. Because if we do not.
And second proviso is an exception to 8C. So and therefore, when second proviso is invoked,
yes,
8C will remain dormant.
No, 8C will not remain dormant. 8C, the first part.
Mr.
It's not a question of dormant, my lord. The proviso is only an exception.
Mr. Ganguly, frankly speaking, I'm so incapable a person. I'm unable to understand you for the last 7 days. Now make me understand.
My lord, the 8C first part deals with the general rules applicable for candidates across the board, and the second proviso deals with the reserve category candidates specifically. Because, my lord, if
Mr. Counsel, please answer. What do you mean by the expression carves out an expression? Then you explain that.
Yes, my lord, 8C.
What? No, forget about 8C. What do you mean by the expression you used carves out an exception?
Exception for the reserve category candidates. Because the reserve category.
No, what do you mean by the expression exception carved out? What does exception carved out means?
Not. No, if I may read, my lord, then the allotment.
See, a normal English grammar, English language gives the meaning that when an exception is carved out,
yes,
whatever exception is carved out is no longer applicable to the other part from where the exception has been carved out.
Yes.
Meaning thereby,
yes,
only the carved out expression will prevail and the other part will not prevail.
Yes, prevail.
This is the normal understanding in English, and don't tell me that my English understanding is also wrong.
No, I have never
now, what is your submission?
My submission is that, my lord, 8C applies across the board, my lord, to all candidates. But if the second proviso is not applied.
So this is the meaning we're asking you. Suppose for reservation, second proviso is applicable.
Yes.
For the reservation part, what will happen to 8C? It will.
No, it will not, my lord, because 8C, the proviso.
It will remain. Okay,
it
fine.
Will remain.
Yes.
It will remain.
So very well understood.
Because if it doesn't remain, my lord, the second proviso.
We are not asking anything more. So 8C will also remain. Yes. Proviso will also remain. Very well.
Both have to be read together.
Okay, now.
Now, my lord, the reserve category candidates are not specifically covered by the first part of 8C, nor by the first proviso. That is why, my lord, the second proviso has to be read with.
This is what you have the habit of saying no. Your habit of saying we are wrongly understood. Meaning is same.
Yes.
Meaning thereby for the reserve category, 8C is not applicable.
The first part is applicable to all candidates, because it deals with allotment. Without allotment, no.
What do you mean by first part?
The first part means the first parameter. If I may read.
That's not the first part. That's the main provision.
Yeah, that is the main provision. The 8C, the first part, I mean the first parameter. Because
it applies to all.
Yes, okay. It applies to all candidates, whether general or otherwise. Because it deals with allotment. If there is no allotment, there is no question of choice or reserve category or any.
So even for reserve category candidate, 8C will remain as 8C
it is. 8C will remain because it applies to all.
So now what is your submission?
If we take the first proviso, provided that in case of non-availability of seats in the college or course of his first choice, a candidate shall be allotted seat in the college or course of his next order. This applies to all candidates. If I do not get the cutoff marks for a particular college, for instance, if the last cutoff is beyond my marks, then I will get in the next college. So it applies to general, reserve, everybody. But specifically for the reserve, if I am within the general category, if I am getting more marks or equal marks to the general category candidates, then I am to be adjusted in the general category. it is only a deemed adjustment. I get as a general category candidate, not as a RC money. That is the limited exception.
Okay. Yes, Mr. Gogoi, anything more you want? Heard Mr. A. Ganguly, Learned Counsel for the petitioner. Also heard Mr. B. Gogoi, Learned Counsel for the Medical Education Department of the Government of Assam. And Mr. D.K. Boido for the authorities under the National Medical Council. You have to make any submission on behalf of the council? Nothing. The GP from the slippery submissions, we are having a little difficulty in understanding.
Which one?
Any slippery submission made, we have little difficulty because we have to dictate one order.
Not.
If your submission is slippery, the order will also be slippery, and it will not carry any meaning. So I always invite a definite submission that this is my submission. Then we'll test your submission as per law. That's why we invite a more specific submission. When you try to make it a little vague, a little here, a little there.
My submission is the same as
but
this,
we found it little
stand
here.
of the learned amicus also.
Amicus, we are not taking note of any submission. We are taking your submission because it's the same submission. How many writ petitioners? The writ petitioner Dipanjan Sharma is a candidate for the first year for admission to the first year MBBS course for the year 2023 in the medical colleges in Assam. In the NEET examination, Mr. Gogoi, in the NEET examination,
Yes,
in the NEET
UG
2023, NEET bracket UG 2023, the petitioner secured how much marks?
543.
543 marks, and he belongs to the unreserved category.
EWS, not unreserved. He is from the EWS category. He's a reserved category.
Without being URU cannot be EWS.
No, EWS only means that otherwise general.
Adjourn the matter for further hearing to be listed in the end of October.
Because it is very much there in the admit card itself. That is been
No, we have to hear you. We are still not understood you till now. We'll hear
because
you.
you are EWS, my learned friend can clarify whether he is UR or
We are not on
EWS.
any disputes here. We'll hear you. Every time we focus on something, you create unnecessary. And Mr. Ganguly, you always have a habit of.
Because I am only correcting whatever, because the wrong something wrong may come in the order. I am trying to assist your
The
lordship.
petitioner to substantiate as to why a EWS quota is not a UR.
The EWS is a vertical reservation. It cannot be UR.
Is EWS also available to the others?
Well,
Is
No, these are
EWS
vertical
also
reservation
available to the others? No.
no,
You have to be UR first.
no, EWS now, my lord, as on the
I know it's a vertical, but first you have to be UR and then claim under the EWS. Because if you are something else, you cannot claim under EWS.
EWS actually, EWS candidate can be, my lord, otherwise he may be OBC also, my lord, he may be SC also, my lord. Otherwise,
Possibly no, check up.
No, he cannot be. When he applies, he has to either choose
No,
UR
yes,
or
that's right.
EWS. He cannot
Or
choose
EWS.
both. He has to apply under the EWS.
After the constitutional amendment, my lord, the EWS is an independent.
I know. ठीक है, लिखो पड़ा, ठीक है।
That is why it is indicated in the admit card and score sheet.
ठीक है, belongs to the EWS. As per the provisional selection list issued by the authorities, the petitioner appears at serial number. Where is the name?
774.
At serial number 774.
Otherwise, rank will be 9416.
Sorry.
His rank will be, my lord, 9416. EWS rank 9416.
General EWS.
No, just a minute. 774.
My.
Even 74 is some here
No,
also.
that is there are two ranks here, my lord, given.
We are on the not on the rank, serial number. Serial number 774 is here also.
Lord, serial number wise, it would be 685.
685.
Page 88.
Serial number 685.
Page 88. Third from the top.
680 at serial number 685 with registration LSR number 707 and revised state rank 774. The petitioner was denied an admission in the first year MBBS course as a EWS candidate. Now, what is your case?
My case is that, my lord, all those candidates of the EWS category who have got, my lord, more marks than the last general candidate, that is above 552. All
552. Where do you get 552?
552, my lord. This is the first list. There are other lists.
I understand. No, 552.
Yes.
552 is serial number.
That will be serial number 591.
500. Sorry, 500. 552.
552 marks.
52.
Serial number 590 would be as per the first list.
Did you do at serial number?
590. Marks are 552.
No, 552. There are a lot of people from serial number 584 to.
Yes, lot of. I'm going by the last one only.
Last one is
Ananya Boraman.
Last one is Nafiza Kosara Rahman, 595.
No, she would be again, Maloj, an EWS candidate. So I'm not going by EWS. I'm going by only the UR. Because if
you are okay.
Yes, because if your lordship comes to after Nazifa.
No, you were on Ananya Bora.
Yes, I'm on Ananya Bora. She is the last UR who has got on her own merit.
The petitioner has raised an issue that the last cutoff mark under the UR category being 552, which is serial number 590, registration L serial number 610, state rank 668 in respect of Ananda Bora, who was admitted in the Kokrajhar Medical College. All the other candidates who were admitted as under the EWS quota are deemed to have been admitted as UR candidates in view of the second proviso to the Medical Colleges and Dental Colleges of Assam, regulation of admission into first year MBBS pro BDS courses, Rule 2017. I think this is your submission.
Yes.
In the event all such EWS quota candidates who secured either 552 as that of Ananya Bora or higher comma, who are otherwise allotted a seat as EWS would have to be construed to be have been admitted as UR, resulting in one corresponding EWS, one corresponding UR seat to be converted to a EWS. And accordingly, the petitioner having secured what is your marks? Having secured 543 marks and who had applied as a EWS candidate would be entitled to a seat in such resultant EW seats upon the conversion by invoking the provisions of the second proviso to the rules. Are we clear about your submission? In view of the aforesaid submission, the only consideration, only issue to be determined in this petition is as to in what manner the second proviso of Rule 8 of the rules is to be interpreted. For a ready reference, the entire Rule 8, including the provisos, is extracted as below. Mr. A. Ganguly, the counsel for the petitioner, by referring to the second proviso, providing that a reserved category candidate in clauses 5A, B, C, D in the Schedule 3 to the rules, if entitled for selection on the basis of his/her merit position in the UR category, comma, they shall have the option of taking a seat in the college where a specified number of seats have been kept reserved for a reserved category, but while computing the percentage of reservation, shall be deemed to have been admitted as an unreserved category and not as a reserved category. And therefore, in the instant case, all such candidates in the EWS quota who were offered admission prior to Ananya Bora at serial number 590 would now have to be deemed to have been admitted as unreserved candidates. And therefore, the EWS quota against which they were admitted shall now be made available in respect of any unreserved quota after the serial number 590. It's okay, Mr. Ganguly? Mr. Ganguly further refers to the further provision of the second paragraph that under such circumstance, by referring to the subsequent provision of the second paragraph that under such circumstance, one seat of the unreserved category of another college of her next preference shall be converted to the respective reserved category of that particular candidate. The meaning Mr. Ganguly, Learned Counsel for the petitioner, seeks to give is that when serial number 589, Mosumi Mondal, was admitted as a EWS, the said admission ought to be considered to be an admission under the UR category. And upon doing so, the quota for the EWS against which Mosumi Mondal was admitted shall now be a EWS seat in the college where Mosumi Mondal had given her second preference. Is it a meaning? Where Mosumi Mondal had given second preference, that one.
Mosumi Mondal did not get under EWS. She is an EWS candidate who has been accommodated under UR.
There is no conversion.
The last EWS is 568 marks.
568
marks.
The serial number?
Yes, serial number. Jhalak Jalan serial number
560?
No, 425. 425.
20.
Serial number 425.
400.
Yes, page 76.
5.
She is the last EWS who has got as EWS.
425.
Yes.
It's 425 over Jhalak Jalan, having secured 568 marks. তাৰপিছত ক'ব ঝলক জালানৰ যিটো EWS হ'ল that ঝলক জালানৰ second preference seat in the college shall now be EWS. It is the further submission of Mr. A. Ganguly, Learned Counsel for the petitioner, that the second proviso to Rule 8C carves out an exception of the main provision of Rule 8C. And therefore, it has to be given an independent meaning of its own. Which decision you relied on carving out? That proviso carves out an exception.
I have given one copy, my lords.
No, forget about the given. Find out. Let's go take in videos. Kuntu.
Well, this is a AIR 2003 SC for WC Ali MK and others.
Which paragraph you were relying?
Paragraph 9 onwards.
Paragraph 9. What is this? It would be appropriate to note the effects of a proviso of a deeming provision. That one.
Yes.
Here comes on dictionary. Overall. एक मिनट मारो सर नहीं नहीं कोस्टी सुगरी नहीं just come back to it. Before, what is the difference between an exception, a proviso, and a saving clause? Because you have argued that the second proviso carves out an exception by referring to this.
Yes, proviso is always an exception, my lord, because otherwise it would fall.
So then, under the law, why three different conceptions are brought in? One is an exception, one a proviso, one a saving clause.
Here, my lord, there is
Because
no,
otherwise, there would not have been any exception. There would have been only proviso, because proviso brings an exception.
yes.
Why do you have two different concepts of proviso and that of an exception?
My lord,
Although you relied upon this judgment, we have taken note of it, but we also have to go through the entire gamut of the law.
ultimately, my lord, it means the proviso carves out an exception because, my lord, and I.
No, then the entire provision would have been provided as an exception and not as a proviso. If it is a exception simpliciter, that by virtue of the second proviso, you forget about everything else, just take note of the second proviso, then the second proviso would have been incorporated in the statute as an exception and not as a proviso. There is a difference. If you want to, you can go through it. Sorry, Ganguly, learn counsel for the petitioner. তার আগতে কি লিখিলো লাস্ট সেন্টেন্স the main provision, main enactment word, the main provision হয় itu provision, itu main enactment of rule 8C. To substantiate the argument, Mr. Ganguly relies upon a judgment rendered by the Honorable Supreme Court in Ali MK and others versus State of Kerala and others, reported in, what is this?
AIR 2003, SC.
AIR.
2003 SC 4006.
In AIR
SC.
SC
Well, yeah, I'm sorry. AIR 2003 SC.
Where is it written? I see
400.
one SCC citation.
No, SC is there.
AR is not there.
First line.
AR, huh?
AIR 2003 SC 4006.
AIR 2003 SC 466.
400.
4006. এইটো হেৰিটো পাম নেকি SCC ভাৰ্চনটো পাম নেকি চোৱাচোন SCC ভাৰ্চনটো চোৱাচোন 2003-11 SCC 632 okay. This is from what? Indian Law Library. It's a online version.
SCC is also there.
No, we want to take out the SCC because the
SCC is there, man. 2003.
paragraph layouts are not very distinct here.
Yes.
What is court? What is the judgment of the court? These things are very difficult to.
Yes, that part is not here. 2003 volume
311 632.
632.
relies upon reported in 2003-11 SSC 632, wherein in paragraph 10, it had been provided that the normal function of a proviso is to accept something out of the enactment or to qualify something enacted therein, which but for the proviso would be within the purview of the enactment. And further, that the proper function of a proviso is to accept and to deal with a case which would otherwise fall within the general language of the main enactment, and its effect is confined to that case. This is what you are trying to say? This line. And further, that as a general rule, a proviso is added to an enactment to qualify or create an exception to what is in the enactment, and ordinarily a proviso is not interpreted as stating a general rule. Paragraph 10 or is extracted as below. Based upon the provisions in para 10 of the judgment rendered by the Honorable Supreme Court in Ali M.K. Supra, Mr. Ganguly Learned Counsel submits that the second proviso to Rule 8C carves out an exception to the provision of the main enactment of Rule 8C. And therefore, the second proviso would have to be read independently of the main enactment of Rule 8C in respect of EWS category candidate who has to be deemed to have been admitted as a UR candidate under the said second proviso. Full stop. Apart from para 10 of the judgment written by the Honorable Supreme Court in Ali M.K. Supra, in paragraph 12, it is provided that if in a deed an earlier clause is followed by a later clause which destroys altogether the obligation created by the earlier clause, the later clause is to be rejected as repugnant and the earlier clause prevails. But if the later clause does not destroy but only qualifies the earlier clause, then the two are to be read together and the effect is to be given to the intention of the parties as disclosed by the deed as a whole. Paragraph 12 is also quoted as extracted. If we examine the submission of Mr. A. Ganguly, by referring to paragraph 10 of the judgment rendered in MK Ali Supra that the second proviso, by carving out an exception, had rendered the main enactment of HCB to be inapplicable in respect of such candidates who are otherwise of EWS category, but also can be said to have been entitled to a seat under the general category, comma, we have to start sentence. We also have to test the seed submission as per the provision in paragraph 12 of the judgment of Supreme Court in MK Ali Supra. In other words, we have to examine as to whether the second proviso completely destroys the main main enactment of Rule 8C. Full stop. If we accept the submission that the second proviso, by carving out an exception, had completely destroyed the main enactment of Rule 8C, comma, by following the proposition in paragraph 12 of the judgment of the Honorable Supreme Court in MK Ali Supra, it has to be accepted that the second paragraph, in that case, the second paragraph, second proviso to Rule 8C would have to be rejected as repugnant, and except that the main enactment of 8C would prevail. Under the laws of interpretation, we have three different concepts. That is a proviso, one inverted comma, proviso, comma, an exception, one inverted comma, or a saving clause. And one inverted comma, an exception, inverted comma, exception, an exception is intended as per the principles of statutory interpretation, 14th edition by Justice G.P. Singh at page 231, comma, an exception is intended to restrain the enacting clause to particular cases, semicolon, whereas a proviso is used to remove special cases from the general enactment and provide for them specially. But at the same time, it is also the principle of interpretation. While dealing with inconsistencies and repugnancies of a statute, that, one inverted comma, it should not be lightly presumed that the Parliament had given with one hand what it took away with the other. With reference to the pronouncement in Dormer versus Newcastle on Tyne Corporation, reported in 1942 All England Report 531, which had also been referred by the Honorable Supreme Court in Tahsildar Singh versus State of UP, reported in AIR 1959 ST 102, K.M. Nanavati versus State of Bombay, reported in AIR 1961 ST 112, and Krishna Kumar versus State of Rajasthan, in Macbeth versus Ashley, reported in 1874 to SC-N division 352 bracket HL, comma, which was also considered by the Honorable Supreme Court in Raghutila Katirtha Sri Padangala Mavaru Swami bracket 3 versus State of Mysore, reported in 1966 ST 1172, comma, a proviso is normally in the nature of a qualification or exception, and therefore it does not nullify the enactment. Full stop. By referring to the said provision, comma, paragraph 10 of the judgment of the Supreme Court rendered in Ali MK Supra, as referred by Mr. A. Ganguly, Land Council petitioner, that a proviso carves out an exception from the main enactment, comma, would have to be understood that although the proviso is in the nature of a qualification or an exception, but it does not wholly nullify the main enactment. By following such proposition, we have, and by referring to the proposition laid down in para 12 of Ali MK Supra, we have to understand that the second proviso to Rule 8C had not completely destroyed or nullified the main enactment of Rule 8C. But on the other hand, the two provisions are to be read together and conjointly, giving the meaning thereof as contained in both the provisions. We also take note of the principles of interpretation. that a proviso will not normally be construed to be reducing the purview of an enactment to a nullity or to take away a right clearly conferred by the enactment, but it has to be held that we also have to take note of the principles of interpretation that a sincere effort should be made to reconcile the different provisions in case of an apparent conflict, bearing in mind that Parliament will not sit at the same time give something by one hand and take back the same thing by another. And if, however, there appears to be a real conflict, comma, a question will arise as to which of the two conflicting provisions should prevail, and that the answer to such questions should not be so much to depend on the form of the provisions or on their sequence in the statute as on their substance, by determining which of the two provisions is the leading provision and which of them is a subordinate provision. In view of in the background of the aforesaid principles of interpretation, when we look at the provisions of the main enactment of Rule 8C and the second proviso, it is noticed that Rule 8C provides that after scrutiny and verification of the documents of the candidate, if found eligible, the selection board shall allot a seat to the candidate in the MBBS/BDS course in a college according to the choice of the candidate, subject to availability of a seat in that particular college at that point of time. On the other hand, the second proviso provides that if a reserved category candidate is entitled for selection on the basis of his/her merit position as a UR under the UR category, such candidate shall have the option of taking a seat in the college where specified number of seats have been kept reserved for a reserved category. And, but while doing so, one UR category seat of the other college of the other college of his next preference shall be converted to a reserved category seat of the particular college where the candidate was entitled for selection on the basis of merit. As per the reading of the second proviso, the expression one invert comma, one seat of unreserved category of another college of his her next preference, comma, would have to be read not to be the otherwise second choice college of the given candidate, but it has to be construed to be the choice, or it has considered to be the college where the candidate had opted to an admission in a reserved category post. Subsequent to being entitled to a selection on merit as a EVER category, তিনটামান sentence. Full stop. The expression another college of his her next preference cannot be given the same meaning as that of the, where is the provision that you can give multiple choices as per your college choice? One provision is there. That while filling a form, you have to give your first, second, third, fourth, all those choices. Or it is in the admission form, somewhere it is there.
It is in the admission form. Online form.
I key over here as that of the choices of colleges that the candidates are required to mention as per the format of the online admission form. When you read the provisions of the main enactment of Rule 8C and that of the provisions of the second proviso, it would be noticeable that Rule 8C would be the leading provision, whereas the second proviso would have to be a subordinate provision. In the background of the aspect that all applications for admission to the medical, to the first year MBBS seats are necessarily have to be made by providing the first, second, third, etc. choices of the candidates of the medical college where the candidate intends to apply for. The choice of medical college to be stated at the time of the application form itself makes it discernible that it is the requirement of the admission procedure that a candidate will take a call on his choice of a medical admission vis-a-vis his performance in the qualifying examination and claim for a first preference seat in any of the medical college where the candidate may be confident of being offered a seat. From the aforesaid requirement of the procedure as well as the provision of the admission form itself, it has to be understood that 8C is a leading provision. It further has to be examined as to whether the second proviso, by providing that a person who is entitled to a seat in a given college on merit also has the option of taking a seat as a on merit as a UR, also has the option of taking a seat in another college as a reserved categories candidate. Comma would have to be understood on a conjoint reading of the main enactment of the provision, main enactment of Rule 8C and that of the second proviso. The expression entitled for selection on the basis of his merit position in the UR would mean that a candidate as per his first choice college is entitled to a seat on his or her merit as a UR. But the same candidate also, by virtue of the second proviso, also has the option to opt for a reserved category seat in any other medical college. And if that happens, the reserved category of that medical college would be deemed to be converted to a UR seat, and the reserved category will be converted and the reserved category of and the reserved category seat of that particular of that college would be converted to a your rules are also very complicatedly worded. Very difficult to give one definite meaning.
At first reading, entirely confusing. Just a small interruption. Lordship may make a passing reference to those judgments that I have relied upon, other than Ali MK, that compilation that I have given.
I think we have to continue tomorrow. It will take some time because
I was just reminding
because lots still remains to be stated also.
I didn't want to interrupt in the middle of a lot.
Okay, well, that's good because otherwise we also
Yes,
lose
the
our
flow, my lord, is disturbed.
what are the other judgments? On
Lord,
what point?
One lordship has seen in some detail, my lord, that is the judgment in Tripurari Sharan's case.
That we take.
That lordship.
Then that we already have in mind. And other one?
Other three are there, my lord. Saurav Yadav is there. I have given all.
No, for what purpose? What's the legal issue?
Basically, my lord, there is no difference among these judgments. I don't want to repeat it.
Saurav Yadav is also related to some interpretation.
It is on the horizontal reservation, but it does make a reference at para 59 to the principles of vertical reservation, how is to be done. It's a 3-judge bench decision.
Do you have to take note of it here? The issue is, I think, a little different
same.
from that.
Tripurari Sharan has summed up. Has summed up, and the other the judgment that is the BSNL versus Sandeep Chaudhary. That is the judgment. It has basically encapsulated all the judgments, right from Indrasani to up to Saurav Yadav. It basically reiterates.
But basically, we feel 8C cannot be destroyed totally. This is our you tested in a bit.
Just a passing reference to those judgments, you know, so that
because otherwise, what will happen? The inconsistency we have not stated, but we can also state. If he says second proviso totally destroys 8C, okay. In a given case, suppose there is no result, nothing. Forget about reservation. As the reservation is not there, a candidate will be given as per his first choice, second choice. The worst of the candidate will make an attempt of first choice of the worst of the college, thinking that I directly make it. He has a right under HC. HC is choice, right?
Choice.
Now, if the same candidate is also involved as a reserved category candidate, in that case, HC will not be there. It cannot be. For two different situations, for one situation, HC will be hold the good. In another situation, HC will not be there. That cannot be an interpretation. HC is either wholly there or HC is either not wholly there, wholly not there. Otherwise, there will be another confusion. Suppose one UR is there. There is nothing to do with any reservation, no EWS, nothing. He knows that I am not a very good student. He knows his capability. Of the all the 6 colleges, which is the worst of?
Now there are 12. Now there are 12.
No, forget it. Let us confine to 6 because others are not there. Which one is considered to be the least preferred?
Otherwise, clearly it is
Tezpur. So that candidate will not take any chance. He'll give his first choice as Tezpur because he knows HC. Because they say, why should I make a fool of myself by giving Guwahati, Silchar and AMC, etc. Let me give Tezpur.
Choice filling is done at the time of counseling, by which time they know their marks.
No.
So I know my
choice
marks.
is mentioned in the form itself.
No, not at the time of no.
At the time of
Not at the
counseling,
time of
there is a
form.
counseling form.
At the time of counseling, my lord, when the
Very
result
well,
is
at the
declared,
time of counseling. So he mistakes.
he knows his marks.
The man stakes a claim.
Yes.
He will have his own assessment.
He may give GMC, but
he has his own assessment. And the man who is not very good but wise, he will straight away opt for Tezpur. I don't want anything else. Let me mark Tezpur first choice. Why should I be having chasing Mirage or something that I will get in Guwahati and all? So for him, it is entirely HC.
Yes.
But for some reason, this same man is also EWS. Now, after getting into Tezpur, he eyes a seat in Jorhat. One Jorhat EWS is available as per his calculation.
Yeah.
Now, make me Jorhat. Then what will happen if I go by the interpretation given? It will become redundant. For the same situation, same man, if he does not go for Jorhat EWS, for him relevance is HC, Moment he goes to Jorhat, HC is obliterated. It is only the second provisor. So therefore, what we feel that para 12 will play the thing. The two are to be read together.
They have to be read together.
Once it is read together, the only thing we feel is that your interpretation of this expression, selection on the basis of merit, is as per your first choice.
But choices, any
so
number
now,
of choices may be made. There is a provision of making 12 choices. I can make any choice, but unless I get on merit.
But the order of the choice is also relevant.
That is there. But unless I get on merit.
So this is what we are basically providing for.
Only a reference may be made to my.
Definitely. We'll try to make it around 3:30. I think it will be over.
Then tomorrow.
Tomorrow. Because he'll need some time to go in appeal also before 30.
The admission date is
30.
Date is almost there.
30.
And
no, we can't shut out your appeal time by delivering the judgment on 28 or 29.
No. It's time for in the stay vacancy rank. I don't know whether we get or not.
One thing, my lord, lordship has rightly stated, my lord, EWS, my lord, can be, my lord, granted only to the unreserved category, general category. It's there in the notification.
It is there.
That is why it is general EWS. So it can't be
right.
This one, I'm very sure that sometime back there was a good debate on this issue in the Judicial Academy.
Well, the constitutional challenge to this provision was there.
Facts, I'm quite clear. But if somebody is not accepting it, why should I go into a debate with the person? Let him have his own concept. Because I raised one question, I remember. Why EWS is not made horizontal and not made equally applicable to all the reserved category candidates?
This question arose in the constitutional challenge, Janhit Abhiyan's case. And this was one of the grounds of challenge that you are depriving the SC, ST, OBCs.
But the one vague statement is that they are already descended. But no, there is a difference between backwardness and the difference between economically incapable. So now within the OBCs or within the scheduled caste, there are some scheduled castes who has very less financial support. Some may be having better financial support, although technically both are backward. But there again, there is a difference between the two. Now, if you had put in a horizontal EWS of across the board 10% for everybody, scheduled caste man who is from a very, very poor family could have availed the seat, and there is a reason for that. The boy of that family may not have had the equal opportunity of having his basic education. He must have been always at a disadvantage. You must have seen Hindi movies, somebody reading under a street lamp also.
Double disadvantage, caste and economic.
But at the same time, you are having some people with good financial resources who are also scheduled caste. You are putting both at the same time. So it would have been a more equitable had this been.
This ground was raised.
Had it been horizontally put. And
like the women's reservation or PWD model.
Put it horizontally, give it across the board, and in that case, the URO people also would not have been aggrieved because no portion of their seat would have been eaten away by another category. Everybody would.
That was one of the grounds of challenge, but the majority judgment rejected that.
I don't know. We're aware of it, but I think maybe someday it will be. Sometimes after the years.
Now EWS candidates are doing well, my lord. They have said that there are so many candidates doing well, so this may not be required in future.
No. Doing well and not doing well is very different.
large number of EWS candidates.
See the background of former President Abdul Kalam Azad.
Yeah.
Are we aware of it? Read his
Yes,
book? To what extent he reached? Because of his contribution in the boasting now of every scientific progress. So there is no comparison with competence. Competence, anybody may be most competent. You don't have to be of any forward caste or these or very only for a very rich family will be competent. Nothing like that.
Yeah.
Now, most ordinary also may be the most competent. I don't know.
That opportunity is required. So horizontally, man, that
Then,
would have been more.
but you know, all judgments. After some time, the minority view is again taken the majority view in
Maybe in future,
in a later one. This is having a different background of that one, why it was rejected, because there are innumerable judgments that these reserved category people, the backwardness is inherent in them.
Yeah.
Even in the general Singh case.
Yeah.
That quantifiable data is also not required to be brought in because this backwardness is inherent. You don't have to bring in data to submit.
Yeah.
Following that principle, it was brought in that their economic backwardness is already recognized. So you don't have to bring it to them.
Yeah. But in the Maratha reservation case, contrary view was taken. If you look at seen, I think that quantifiable data was held as a prerogative to require Melody. It was struck down Maratha reservation because Marathas were a forward community. It was found that they had majority representation.
No, rejected. For Marathas, quantifiable required.
Yes,
but for ST and ST not required.
And same in the Jat case also.
That is general thing.
Yes,
general thing is not required. So these are all.
And the rules should have been some clarity. This was better. This sort of exercise perhaps might have been.
See, we're having great difficulty in giving interpretation to your rules. And he made the best of it.
Well, we tried.
Try to make the best out of it because of this loosely worded formulations. Okay, we'll come back tomorrow. You will do it. Again, list again. List tomorrow. List conference. It will retain for tomorrow at the end of the list.